सर बाजू में। हाँ, मैं पूछ के आपको बताती हूँ। हेलो। या हेलो, एक्चुअली हेलो। और कर्नाटक को it's already off.
Court officer, it is muted.
Disposed of as withdrawn with liberty to file fresh petition. Then counsel appearing with the petition has become infructuous. Hence, the writ petition is dismissed as infructuous.
Much.
Cell number 2. N Radha, N Krishna.
Order sheet. Order sheet. No, what is the text letter? No. There should be some other thing, no, after this, after 2810. No. This order is dated 2810. This is dated? Hmm. Please come. When MFA was disposed of, 8/11/2023, this court has passed an order on 28/10/2025, seeking an explanation why a matter which is disposed of on 8/11/2023, extension of time is sought now. A letter is placed before this court dated 12/11/2025, 11/11/2025, stating that the order of the court was received in the court on 29/12/2023, but the record keeper did not read the order properly and failed to put up the file. Later, another order was received on 14/8/2025. While going through this order, the record keeper realized his mistake and immediately brought it to the notice of the judge. Then the judge has issued a notice to the concerned official. And in the reply, the record keeper has undertaken to be vigilant and to not repeat such mistakes. And the official has been warned in this regard. It is also stated that prior to 14/8/2025, no party has filed any application before the court in the case. Hence, it is so unfortunate that an order that's passed on 8/11/2023 it is stated that it is communicated in the year 2025. Considering the request that's made by the learned judge, finally, the earlier what was the time granted? Where is that order? Oh, another 4 months time is granted for disposing of the matter.
Cell number 3. Shankar, furnishing of PF.
Yes,
No such.
a week's time default order. 4.
Cell number 4.
A week's time, same default order.
Cell number 5.
Memo is filed seeking dispensation of notice to R1, dispensed with. Office objection shall be complied within a week, default order.
Cell number 6. Sandhya D.
A week's time, default order.
Cell number 7. Awaiting.
List after
Number 8.
This also after service of notice,
Cell number 9, non-compliance.
Fixed time, my lord.
a week's time.
Cell number 10, Gita.
That's insurance company appeal challenging liability merits.
Council submission with regard to difference in name of appellant and seal affixed in
That's,
wakalat.
there is a typographical error in tribunal judgment, my lord, that the name of the appellant is United India Insurance Company. But they have done a small mistake, my lord, that
That's what
United
I'm saying.
Insurance.
It has become a routine practice for the insurance companies to come up with this kind of, what is wrong with the order of the objection of the section? It should have been your lookout. You should have done all the efforts. I can say it is one case. Every day, in every case, this is what is the submission. Then you should have sought for the clarification. You should have got your the correction to be carried out by filing an application that you are not doing, coming to the High Court. And court should say whatever it is, office should not take the objection. Yesterday also I have your colleague had told that I will not entertain this from now onwards.
Yes,
United Insurance Company Limited.
yes.
Award also must be showing the same thing, isn't it? United Insurance Company Limited. How will anybody execute this order?
That's in the connected appeals, the stay is already granted, my lords.
That's what everybody is saying in all the appeals the court is, because court is entertaining you people are coming every day without seeking any clarification. Yes, Mr. Ravi Samriti, what is happening in all these insurance companies cases? Why should the court look into all this?
Initially, it has not been corrected in the trial court.
That should have been done
And that
there.
will continue.
No. Even after the judgment and award is passed, it is a simple
Yes.
application which has to be corrected. That
But
they are
the-
not doing.
But the
So
trial
now
court,
when the execution comes, how it can be executed?
it can't be executed because it
Because
stays.
there is no such
Yes.
person,
Yes,
such entity.
it cannot be done. No, in spite of bringing it to the notice of the trial court, even the registrar also, no action has been taken. I request your lordship to pass an order on this. Let them be directed because they know there is a big board which has been installed in the city civil court mentioning the correct name of the insurance companies. In spite of that, these mistakes are happening.
No, it is not some private party that all these
Yes.
kind of, and even apart from that, there
apart
can't
from
be a
that,
gender
even the-
direction. It's for the insurance companies to do.
Even the trial advocate must notice that.
Your
at the
counterpart
earliest
should do
stage.
it.
Yes, that has not been.
Please come, the petitioner shall take appropriate steps to correct to seek clarification from the trial court and get the name of the insurance company corrected within a period of 3 weeks. Let's just matter after 3 weeks. I'm telling, I'm very clear now, I will not entertain or not even one application of this nature. Yes.
Cell number 11, Ashok and Patil.
Serial number 11. Its non-compliance minutes is with regard to minutes. There are 2 paragraphs minutes of Kannada minutes, that is cross-examination which is called out. So only that is minutes. I have minutes got the translation copy by way of memo minutes.
Do it in a week's time.
Please minutes.
Cell number
It
12,
may be fixed minutes so that it-
Star.
List is matter next week, a
Please.
week's time is granted. If the office objections are complied, list is matter someday next week.
obliged.
Cell
Yes,
number
next.
12,
That's
Gita.
insurance company appeal, my lords, challenging liability, my lords.
Regarding maintainability of the appeal against the order dated by the council, so and so, appeal is below 1 lakh. You're on what ground?
My lords, on liability, my lords, we are challenging liability.
What is that ground?
My lords, the claimants are the inmates of the car, my lords, and the car has the only liability only policy, my lords, and the risk of the inmates are not covered.
The office has raised the
The stay is already granted in connected appeals also.
maintainability as the, in view of section 173 2 of the act, when counsel appearing for the insurance company submits that the insurance company is before this court on the question of liability, as the policy is a liability only policy and the inmates of the car are not covered, and this aspect was not considered by the court. office objection with regard to the maintainability is overruled.
Not stay application.
Huh?
Stay application is there.
The, considering the, next on IA, on stay, considering the IA 1 of 25. The insurance company is on the question of liability, as it is a liability only policy. There shall be stay of all further proceedings, same 50%, 4 weeks.
Notice.
Published.
Notice to the respondent.
Cell number 13. Rakesh B.
Respondent number one.
Furnishing of.
Hearing for petition. So for
Weeks
respondent
time.
number 3, my lord, it may be dispensed with my lord.
Memo is filed seeking dispensation of notice to
My lord,
third respondent.
on the last date of occasion, my lord, your lordship direction was, if the needful is not done, it will be dismissed within a week, my lord. My lord, since 6 years, I have not, they have not paid the maintenance, my
We will
lord.
hear the matter.
My lord, respondent number 3 is the party, my lord.
They say it may be dispensed with,
But
what is your
respondent number
problem?
3 is the husband, my lord. I am the wife, my lord. And
Who are they?
she is the sister of respondent number 3, my lord.
The dispute is between the petitioner and the respondent number 1 and 2 and the respondent number 3. That is, he appears for wife. And my
That's
lord,
fine.
petitioner number 3 appears for, sorry, respondent number 3.
What
my
is
lord,
this,
the husband.
what is this order?
My lord, maintenance dues, which is liable to be paid by the respondent number 3, was not paid. For that, my lord, the joint family property was proposed to be auctioned. That is challenged before this honorable court on the ground that, my lord, even prior to filing of this miscellaneous proceedings and everything, there is a partition suit pending, and in the partition suit already a decree is passed, against which, my lord, now RSA is pending. It is during the pendency of that, my lord, this application came to be filed to sell the entire property.
A memo is filed seeking dispensation of notice to R3 dispensed with at the risk of the petitioner. This is matter after vacation. Yes.
Cell
Interim
number
order may be
14.
extended.
Interim order earlier granted is. Yes.
Cell number 14. Siddharth Suman. Memo for withdrawal.
My lord, I am for the respondent in this matter. He filed memo for withdrawal. The matter has been settled in this matter.
Settled.
Settled.
The memo is filed stating that the matter is amicably settled. Hence, the petitioner wants to withdraw the petition. Yes, memo is taken on record and dismissed as withdrawn. Yes,
Cell
15.
number 15. Vinay S.
Petition 5 days,
Huh?
5 days time agli sir.
Weeks time default order.
Cell number 16.
Kindly pass on, Lordship.
My lord, in this case, my lord, SA has been dismissed.
Kindly pass
He-
on,
one
Lordship.
second.
Senior is on his way.
13
Senior is on
four.
his way, near the gate is coming.
13,
Just
4
5
and
minutes.
14, my lord, both the,
Ask him to come because
Yeah,
there is no
he-
passover today.
Just 5 minutes.
today is the matter in the
Achha, okay.
DRT.
No,
They
sir.
filed one more essay.
So let the
Sir,
senior
this
come,
came,
we'll
sir,
hear,
near
then you
gate.
can argue on.
5 minutes.
Yes. Yes.
5 minutes.
Cell number 17. Cell number 17.
My ladyship, my senior is joining on.
May I please your ladyship, may I please your ladyship?
Yes.
The all issue here is, I am seeking protection under the notification dated 29/5/2015. And this is a notification which not a single bank or financial institution in this country has given effect to. A law which the parliament has enacted has been given to the dustbin. And my lord, unfortunately, whenever the litigants have approached, MSMEs have approached the courts too, my lord, to a long line of judgments were against the MSMEs. Eventually, in Pronitz, the Supreme Court said the notification is mandatory.
Can you please
It is
come to your
binding.
prayer? At which page?
No, my lord, prayer, prayer A and prayer B.
Page
Yes.
number 53.
Yes. Yes. Page number 53. May I take your ladyship to the prayer? Yes. To declare that, your ladyship got it? Page
Yes.
53. To declare that Annexure F notification dated 29/5/2015 in unmistakable terms declares that the MSME borrower has no obligation to make an application for resolution of stress, and on the contrary, that banks and financial institutions are duty bound to identify incipient stress based on the illustrative signs indicated in Annexure 1 to the Annexure Annexure by RBI Circular dated 17/3/2016, and further that in any case where the bank has failed to identify incipient stress, it is duty bound to classify the account as a SMA1 if the default is more than 31 days, and as SMA2 if the default is more than 61 days.
So
And thereafter
before that,
shall
when
no,
was
let me complete the prayer. Let me complete the prayer. And thereafter shall constitute a committee and make a reference to that committee for resolution of the stress. And further that the committee is empowered to permit recovery in terms of para 543 or if the resolution of the stress is not feasible. Let me read the prayer B also. And in furtherance of prayer A above, to declare that the judgments of the Supreme Court in Pronet versus so and Sri Swami so and so were rendered per incurium and substantial and will not bind the courts and tribunals in this country under Article 141 of the Constitution, in as much as in Pronet the Supreme Court had, contrary to the letter and spirit of the notification, observed that if the MSME had allowed its account to be classified as NPA and for recovery action to be initiated, having failed to bring to the notice of the bank that it is an MSME supported by identifiable and verifiable documents, he cannot be allowed to thwart the SARFAESI action at a later stage. And two, in Sri Swami Sama, the court observed that if the MSME had not even replied to the notice under Section 13(2) and claimed protection as an MSME supported by an affidavit, the recovery action cannot thereafter be challenged, which, to repeat, are contrary to the very letter as well as the spirit of the notification, and have created a scenario where the judgments have been instrumental in denying benefit of the notification to the MSMEs across the country. So where the courts have, contrary to the where the notification statute is the will of the people, and where when a judgment is contrary to the statute, it is not the judgment which will prevail, it is statute will prevail. It is not the judgment of the Supreme Court which is the law of the land. Many lawyers and judges have misunderstood it. It is not, the judgment of the Supreme Court is not the law of the land. The law of the land is the law declared by the parliament. And the judgment is the court, the domain of the court, the province of the court is only to interpret statutes. And that is fundamental principle, universal principle. Just as desere non just dere. The province of the judge is to interpret a statute, not to undo a statute. I always say, even your leadership also occupy this chair which is by virtue of a collegium, which is a creation of a judicial legislation. It's against the basic. There is nothing in the constitution called collegium. It's against the constitution. So therefore, we have been doing this kind of injustice for a pretty long time. The people of this country have never raised their voice, and as a result of lakhs and thousands of MSMEs are denied what was entitled, and the bar is responsible for that. I have not seen. I go around all of this country to tell the bar members of the bar, you have to raise your voice, make the claim under the as an MSME. We have a duty to the litigant public. We have a duty to the court to bring to the notice of the court where the court has erred, to tell the court fearlessly that the court is wrong. It has to correct itself. And the court we don't have to look anywhere. Look at our own Supreme Court. It has got such a history which we are proud of. In Andhra's case, a 7-judge constitution bench said a judgment of the 5-judge constitution bench is rendered void ab initio. A Supreme Court, even the highest court of this country, a bench of 5-judge constitution bench cannot override this statute. If something has been done contrary to the statute, it is a duty of the courts to correct it. And now, my lord, all these issues will come at the stage of final adjudication of the case. At this stage, only I am here before your ladyship only on one ground, that on 8th an auction is scheduled to be held. And if an auction is scheduled to be held, third party rights are created. Let me just explain the leadership. Just hear me on the little bit of legal principles. Then your leadership may agree with me. See if your leadership doesn't agree with me, that's your leadership's right choice. You know, that is absolutely fine. Absolutely fine. Absolutely fine. But hear me. Hear me. Hear me.
Yes.
Pardon me.
State Bank of India advocate is here. I'm asking him to get the instructions. We'll have it on Wednesday. This is matter on Wednesday.
Then the all
The
issue,
Mr.
the auction
Vinay
is on
Shetty
8th.
directed to take notice on behalf of the respondent bank. State Bank of India is the respondent. Respondent
No,
number?
there are many banks are there. Canara Bank is the principal respondent.
Canara Bank.
Yes.
Yes.
And you know, the all issue is what I wanted to say.
Canara Bank
Let me
is-
say one. Let me say one thing more. One word, my lord. This is even the enactment of SARFAESI Act is in ignorance of the.
But I think prayer also sought against Canara Bank.
Prayer is again. Mr.
1 to 3 is
Vinay
Canara
Shetty
Bank.
is directed to take notice on behalf of the bank. Yes, next.
Lady,
List.
the urgency, the auction is scheduled for 8th. That was mentioned.
Cell number.
Leadership may stay the auction. Otherwise, hear me for 1 minute. Why I am saying, and you disagree with me if I am wrong. I don't have any right to be then acceptance of whatever I say. But hear me very briefly on what I wanted to say. The whole concept of the res judicata, that all parties, all causes, all controversies be brought before one forum, and this decision be final and binding, right or wrong. That is the res judicata pro veritate accipitur. That principle is founded on this maxim is founded on two principles, but that is interesto republico ut sit finit litium. It is in the interest of the republic that there shall be finality of litigation. And it is also in the interest of the parties in litigating before the court that there shall not be vexed on the same question more than once. No more debet bis vexare pro uno et lidum causa. Therefore, CPC, which is a codification of the common law principle, first ever in the common law countries, which happened in 1851, codifies the opinions and the on 8th Monday. So
Monday
therefore, if
get instructions on Monday.
Let the copy
Yes.
be third upon.
Yes,
Huh?
I'll
give it.
So the
I'll give
papers
it.
on you. Yes.
your lordship is keeping on Monday, fine, absolutely fine. Yeah.
Cell
I'm good.
18.
I am for the
English
appellant
session.
method. I am for the appellant method.
Yes.
As the delay of 654
Notice to
days in
serve.
filing the appeal.
I number 1 of 24 to condone the delay of 654 days, condone on condition. Admit final hearing TCR. Yes.
United.
Yes, next.
Cell number 19.
Notice to
19 also I am
respondent.
for the.
In this case, I think
Notice.
Yes.
insurance company fee challenging the quantum of compensation.
Or how much is awarded?
23 lakh and odd is the award amount, my lord.
It's a case of death.
It's a case of injury.
Hmm.
They have taken medical reimbursement from the employer.
How much is that amount?
That is 7,99,000.
Hmm.
I have admitted amount, my lord, 12,70,000. 009 is the admitted amount. It may be.
No, when you say that you are disputing on 8, then it is not 12 lakhs, it should be 15 lakhs. When the
Like
amount
that.
is 23 lakhs, your dispute is on 8 lakhs,
Please.
then it is
7.
15 lakhs.
Please.
It is submitted that the land council appearing for the
That the
appellant.
convention at the amount granted is on the air side. Therefore, I am.
Land council appearing for the appellant submits that the tribunal, the insurance company is on the question of quantum, and the tribunal has granted the compensation on a higher side. Further, the claimant has already got the reimbursement of the medical expenses. Still an amount of rupees 8 lakhs is awarded by the tribunal, considering the submission stay on condition of depositing 12 lakhs.
The Lordship can say 13 lakh.
13 lakhs, and on such deposit, within 4 weeks on such deposit, the respondents are at liberty to withdraw. Notice to the respondent.
Cell number 21.
Yes.
Kartik Kiran.
for the petition, my lord. My lord, there's a delay of 797 days in filing of this petition. The difficulty, my lord, is that,
Let that be noticed to the respondent.
my lord, there needs to be a stay on this impugned order as well. For the reason,
Why
my
there
lord,
is delay?
my lord, I was not even aware of the initiation of the 125 proceedings against me, because, my lord, in the cause title, the wrong addresses, my wrong addresses have been was
What are
included.
the other proceedings that are pending between the parties?
My lord, there was a proceedings for judicial separation, and even in the judicial separation
Where is
proceedings,
that you have the petition, the judicial separation application?
my lord, I don't have not produced a copy of the judicial proceedings.
In that, what is the address mentioned by you?
My lord, in the judicial proceedings also was decided ex parte. Two proceedings was initiated against me by the wife. One is the impugned proceedings under 125, and the other was for judicial separation. Both these petitions were decided against me ex parte, my lord.
Where do you stay? Where is this address?
My lord, my lord, I am staying in Mysore. I was staying in Bangalore and Mysore. And my lord, here the addresses of mine that was mentioned was of Ongole, my lord, in Prakasham district, Andhra Pradesh, and my office address in Bangalore, my lord. These two addresses were given.
No,
And
that is not your address.
no, my lord, this was not my address as well.
What is your address then?
My lord, my address, my lord, is in Mysore. My address was in Mysore. As of 2019, I had shifted to Mysore so that I could stay with my wife. But my lord, she had deserted me in 2015 under the pretext of prenatal care for her pregnancy. After the delivery also, up until from 2016 up until 2019, she does not come to stay with me. I travel every single weekend to visit my wife and child. And in 2019, my lord, I set up a matrimonial house in Mysore so that I could have some kind of relation with her. I could build the relationship between myself and my daughter and the wife. But my lord, she does not turn up to my house as well. Later, my lord, in 2022, she initiates these two proceedings.
How did you know now?
My lord, the execution proceedings were initiated.
Let's see your condon delay petition. Affidavit.
My lord, page number 58, 57 and 58, my lord, is the affidavit.
Please read.
Execution proceedings were initiated against me, my lord, and in that, my lord, I was served, an NBW was issued as against me. This NBW comes to be served upon me, my lord, in the month of September 2025, after which, my lord, I am before this.
The address is located where it is served on you.
My lord, it was served on me in Mysore, my lord. My lord, that apart, my lord, the impugned proceedings and the impugned petition, my lord, if I may take your lordship's attention to the petition in page number 46, my lord, annexure E.
Yes.
Page number, my lord, a host of allegations are made against me, stating that I was physically violent, stating that I had the habit of gambling, and that I have the habit of.
What is the amount that is granted?
My lord, the amount that is granted is 40,000, cumulative amount of 40,000, and that I have to bear 75% of the expenses of the child's education, my lord. My lord, here the difficulty that I'm placing before your lordships, my lord, is that the respondent number one, she's a dentist by profession. That's number one. Number two, my lord, in the petition itself, she makes a host of allegations against me, stating that I'm physically violent and that I have the habit of gambling.
And what is your occupation?
My lord, I am working in the IT sector.
What is your salary?
My lord, the salary, my lord, I have never had an opportunity, my lord, to place on record a statement of my assets and
You can
liabilities.
tell the court now. You are before the court.
My lord, I need to seek instructions as to the
Get
current.
instructions will take up on Monday.
My lord, if I may submit, my lord, if I just one submission. Throughout the host of allegations that she has placed, my lord, in the petition, my lord, none of these allegations are substantiated with any evidence, my lord.
All that are not required in 125 CFS.
My lord, as per 125, my lord, if the as per 125 clause 4, if proper reasons are not assigned as to why there was a desertion or why the wife is staying separately, then there is a direct bar under 125 clause 4, my lord.
The court will not do such probing inquiry in that. Please get instructed. This is matter on Tuesday. Yes, next. At the request of non counsel, the petitioner. Yes, next.
Serial 22.
My lord, I am for the petitioner.
The respondent,
Honorable court on the
respondent
3rd
number
June. 3rd June directed to await for the orders of the Honorable State Consumer Commission. The order also I have filed along with the memo. And the order clearly says we are ready to follow the order of the Honorable State Commission. And only thing is we are ready to make the payment as agreed before this court also. Therefore, the respondent number 1 and 3 have to register the property.
Yes,
Your Lordship, the respondent number 1 has agreed to register the property in the name of the petitioner because the orders has already been passed by the State Commission. We are even the draft of the agreement has also been approved, Your Lordship. So we are duty bound to do it.
where is that order of the State Commission?
It's a memo I have filed, Your Honor. On page number 6th November, I have filed along with the certified copy.
In that case, why you require any further order from this court?
Because the original power of attorney was with the land builder, who is a respondent number 3 here. So 1 and 3 together have to execute this sale deed. That's the problem. In State Commission, it was only respondent number was with the party, not the number 3. So when the last occasion, when the respondent represented before the State Commission, they said they have to seek the permission from the landowner, that is Ara Properties, respondent number 3 here. Hence, the direction has to be given.
How can we give a direction now? The writ petition is maintainable as far as the bank is concerned. No,
This was pending. Registration was pending because of the bank dues was not there. Bank dues has been cleared. Now we have cleared.
If the third respondent is ready, he is ready.
He's ready, but the problem is the power of attorney of registering the property is with respondent number 3, Your Honor.
I'm saying for respondent number 3.
He's a party. He's a party in this case.
Maybe.
No. This is in this case because of this respondent number.
Come to the prayers you have sought. Please come to the prayers. What are the prayers that you have sought?
No prayer in this.
You to quash the proclamation of sale dated of the scheduled property by the recovery officer is 1. To direct respondent 2 and 5 bank to adhere to the OTS. To direct respondent number 3 to register the schedule.
Yes.
This we cannot. This kind of a direction we cannot give.
The reason is before this court we were there because the respondent number 1 didn't have the power of attorney was cancelled by the respondent number 3. That is why there was a dispute. There was a paper publication. The property could not be registered, my lord. So hence we approached the State Commission. Now the respondent number 1 is ready to register the property, but the power of attorney of the land is the respondent number 3. That is the question. That is why I am before your lordship.
But I don't think this court.
No, an order can be passed that in view of this one.
Why should we pass? Why should we pass an order against a private party to say that you registered the land in favor of the petition?
No, it's a matter of principles of natural justice. I'm seeking the
principle of natural justice.
My lord, some
have jurisdiction to do things, then only we should do.
No.
Everything
I will just read out the order of this honorable court on 3rd June. May I?
Yes.
Learned counsel for the petitioner submit that Karnataka State Consumer Commission has directed the execution of the sale deed by respondent number 1 in favor of the petitioner on payment of certain amount EA number 44 of 2021. He submit that the calculation of the amount have to be also been filed and the petitioner is willing to make the payment of the said amount. Learned counsel for the petitioner submit that the due amount will be paid simultaneously with the registration of the property. Along with that, the petitioner would also be making payment of stamp duty and registration fees as applicable to the said registration as on date. In that view matter, list on 23/7/2025. Accordingly, the State Commission has passed the order and the amount has been declared and amount to be paid. And we have agreed also, we have written a letter to respondent number 1. We are ready to make the payment at the time of registration.
You have
My submission, Your Honor.
From the State Commission. You have an order from the State Commission.
Yes.
You will get it. Now, what prayer you are seeking before this court against the third respondent is beyond the jurisdiction of this court.
No, the very fact it went to DRT and other things because of the respondent number 3 not registering the property. Because earlier the power of attorney was vested with respondent number 1. It was cancelled by the landowner who is respondent number 3. Now, unless I get a
That cancellation and the inter se disputes between you and the third respondent.
no, I'm nothing to do with the landowner. My property is from the respondent number 1. The relationship is from the respondent number 1 and 3. Now my my lord,
it is their duty to clear all
my
that.
lord, the problem is they have little problem unless a small direction is given. The property can be registered. Simple, a direction to respondent number 3 to coordinate with respondent number 1 in executing the sale
Respondent
deed.
number 3.
Respondent, they have filed the wakalat. They were present and they are not coming at all for any hearing.
No, the relief that
No,
you're
no,
seeking is beyond the
No,
terms of
ample
the
submission,
prayer
Your Honor, my right under Article 14, my property is under question. It has to be, only my submission is to coordinate with the respondent number 1 to register property. That's all I'm seeking, nothing else. Payment, everything I'm ready to make as per the orders of the State Commission.
that you do. That
No,
you
no,
do.
I'm ready to do, but one small direction so that you can dispose this.
We cannot
No, you
give
can
a
dispose
direction
this
to an
writ petition
unofficial
itself.
respondent to settle some disputes between the petitioner and
No,
the
no, it's not a dispute, my lord.
No dispute,
No,
then you
no,
go.
it's not a dispute. I'm seeking a prayer that directed respondent number 3 to coordinate with the respondent number in executing the property. That's all I'm seeking, nothing else.
Why should we say so?
Because of that problem with the respondent number 3, this entire writ petition is hanging on since 2017.
Then you should have done something as some other, your remedy is not before this court. If you have a dispute with third respondent.
Earlier it was with the bank was cleared, everything is over. Now the builder had raised some issue that also was settled with the State Commission. Now the problem is, my submission is, unless the respondent number 3 is participated, property cannot be registered. That is what they made the statement before the State Commission. That's why I'm before your lordship.
That order in a writ court.
No,
cannot
some
pass.
kind of relief I require on this writ petition. What kind of relief I can get at least? Your Honor,
We can't pass orders just like that.
No, I'm not. A relief under 226, I am entitled, Your Honor.
What is relief? You're
Relief
entitled-
is that at least.
Under 226, are you entitled for a relief against a private party?
No, not private party.
Your entire writ petition is based, all the reliefs are against the bank. That is what gives jurisdiction to this court. Now you and the bank have settled the disputes. What if the third person respondent is ready to participate in the registration process? You get it done. If he is not ready, you have a common law remedy.
No, it was not like that. The very fact bank issue came up before this court on account of respondent number 3 not coordinating with the respondent number registering the property. That is why this DRT it came up in this picture. Otherwise, it would not have come. The entire petition came up on account of respondent number 3.
Even before the consumer forum, they are not the party. Whatever order that's passed by the DRT, consumer forum is not binding on the
No,
third
they were not
respondent.
made the party, only the bank and the respondent number 1.
So that is not binding on him.
My submission, Your Honor, please. At that time of filing the State Commission in complaint, the respondent number 1 only had the power of attorney to execute. Subsequently, the power of attorney was withdrawn by the landowner. That is why I'm making submission that to direct the only just to coordinate with the respondent number 1 registering the property. It's a genuine submission, Your Honor.
You can take a chance after vacation, after this matter.
Interim order can be extended.
Yes.
Number 23.
Your Honor, respondent number 3 was participated.
And counsel for the no representation on behalf of respondent number 3. Counsel for respondent
Maybe
number 1 is
directed
present.
to present before this court so that he. No, Your Honor, we have cleared the amount.
Can there be a direction to
it's
the advocate to appear
No,
before the court?
simple is this entire writ petition came on account of the respondent number 3. That is why my
Yes, after
submission
vacation, no representation for respondent number 3.
may be directed to appear before this court, respondent number 3.
It's really strange, the submission you're making.
No, they are not
Will there
coming.
will there be an order like that? If it is a petitioner, we'll post it for
No,
dismissal. Otherwise, we'll record it next time, we will pass orders.
Okay, sir.
Yes.
Much obliged.
Well, I've actually appealed on behalf of respondent.
Huh?
In
compliance with the direction of this honorable court, valuation was conducted in respect of the property. There's some survey which is required to be done by the government, because in the 2022, when they conducted valuation, that report was given to them. Apparently bank has lost it. We have now undertaken to get it done. It may take some time. I've taken instructions.
What had happened, my lord, my 13 to SL before this honorable court. This honorable court directed on, my lord, 5th November 2025, this honorable court directed me to conduct a valuation, submit before this honorable court, and whether, my lord, because their case is, my lord, that extent of the property is more. If they're, my lord, they're releasing some of the property, my lord, they will pay the money to the bank, and, my lord, it can be regularized or some arrangement can be done. This honorable court directed me to, my lord, conduct the valuation, which, my lord, as per the order made by this honorable court, we visited the, my lord, along with the valuer, by the authorized officer, visited the place, the secured asset, wherein, my lord, survey, my lord, we are not able to demarcate that, because it requires, my lord, government surveyor has to, my lord, conduct the survey, and he has to give a report, so that, my lord, my valuer can conduct the valuation and submit before this honorable court. Therefore, my respectful submission, survey, my lord, I can't conduct being a bank.
I've undertaken, because
some, my lord, my difficulty is this. Interim audit is, my lord, operating. Some, my lord, he would have done
Time
it.
frame, we will fix the time frame.
My lords, already
How
I
many
filed
days?
an affidavit
How
stating
many
that
days?
whatever comes out of that sale will be deposited
How
entirely.
many days for the survey?
My lord, since it is government, that's where my difficulty is. We have filed application, we're following up every day. It may be posted after 10 days, my lords. I'll come up with some update, my lords.
5th November
It is submitted by both the councils that as per the order passed by this court dated
5/11/2020.
5/11/2000, not 11/11.
11 some affidavit has been placed.
Yeah, sorry.
On 11/11/2025, they will, they have conducted the valuation of the property. Then counsel for the petition submits that the earlier survey report, which was with the bank, was misplaced. As such, the survey needs to be conducted. They've already made an appropriate application to the government seeking survey. Hence, request the matter to be taken up after 10 days. So that in the meantime, they will get the survey done. List is after vacation.
Kindly.
My lord, before vacation one day, I'll take a chance. It's huge outside.
This matter
18th, my
on
lords.
18th of December, by the time the survey should be completed, or else the court has to pass orders on the merits of the matter.
My request for any direction, I have not made them as parties. If I have made an application, because they are statutory authorities who are supposed to conduct a survey.
File another writ petition for that. That's an easy way to get the order.
Sorry, man. Grateful. Interim order may be extended.
Interim order earlier granted is extended till then.
I'm grateful.
Number 24 for preliminary hearing.
16th, the council.
Animesh.
Yes.
I apologize for the submission. Matter of 20th matter. 16th.
That's what.
Yeah, I was held up there.
Yes, yes.
I may permitted to, because we have challenged the auction sale before DRT. Today matter is Madam, listed 16. for,
16 pass.
Seal number 16. I apologize, sincerely apologize.
Yes.
I was held up.
Yes.
Wherein
What
I have
was-
challenged the order passed by the DRT under section 14,
Hmm.
which I have supposed to prefer appeal before DRT.
Hmm.
13.4 measure also I have challenged before DRT, that I have already challenged before DRT. And the auction sale, they came out with the auction sale that I have challenged before the DRT. Today's matter is listed today.
What is this matter?
This is section 14. They have taken the physical portion of the property without giving prior notice of 7 days. All my household articles which are not hypothecated is also intact in the house. And the very question of law, I'm invoking the rich jurisdiction. When limited scope is there, I may permit take up this letter because today the auction sale is there. I'm praying for.
No, what all the grounds you have taken before the court?
Yes.
Can't it be taken before the DRT?
The
Because already you have initiated the proceedings there.
DR8 is section 13.4 with regard to possession notice. Here section 14 without giving prior notice of 7 days.
You are questioning the order on essay.
Yes, say both. 13.4 DR8 already I have approached. Essay number 116. This is 105. 116 and 105. So there are.
Sir, on the ground of delay.
Not delay.
On
merit. On merits only. Only limited to the extent of the security interest should have been created based on the agreement. There is a question of law involved. When the agreement says the rate of interest should be charged fixed rate for minimum period up to 2024, the bank should have adhered to the terms and condition of that. After restructuring also, it will not retrospective. It should be from prospective effect. That was a question of law when I challenged before DRT. DRT said only measures. This is lacuna of the dracuna of this SARFAESI Act. Under SARFAESI Act, only our limited scope is measures. Whether measures taken by the bank is in order or not. Only three questions: 13-2 issued, 60 days complied, whether objection has been filed, possession notice has been issued, notice has been served, which is affixed, and conduct the auction. Whereas in the RDB Act, it has extended. It's a large scope is there to determine the debt, whether the debt arrived by the bank is in order or not. That's legally enforceable. That I cannot take up in SARFAESI proceedings. 13-4, the measures taken, the interim order was in force. It got dismissed without appreciating my question of law here. Then I went to DRT. In the meantime, without giving 7 days notice, the bank has taken the possession of the property. All my household articles which are not hypothecated to the bank, they have seized it. Now they have issued one more letter stating that within 7 days, if we don't, we are going to shift to some other place. Again, it will become a multiple litigation. My submission, I may be permitted to make two submissions, my lord. If your lordship going to hear the matter on question of law with regard to security interest, what the act says is,
My lord, in this matter, my lord, with permission, I will place my submission. SCA 105, the measure initiated under the provision of 13-4 has been challenged. My lord, SCA 160, the measure initiated under section 14 of the act, same property, same loan account. Both the essays, my lord, on the same date, on 7/10/2025, both the essays were dismissed by the DRT on merits. My lord, my learned friend, the petitioner has filed an appeal with regard to the measure initiated under section 13-4 of the SARFAESI Act. My lord, he did not file the appeal with regard to the measure initiated under section 14 of the SARFAESI Act. I am permitted to read the averments. My lord, one measures, my lord, on the same measures. 14 is the offshoot of section 13-4. My lord, what he has stated is where, my lord, preparing the writ, an appeal before the DRT. That is the reason that it has been filed. My respectful submission, my lord, the appeal is already pending before the DRT, challenging the measure initiated under section 13-4 of the SARFAESI Act. My lord, I don't know. I am very strange. Why he has not pressed that appeal before the DRT? Could have get some interim orders. My lord, one measures he filed writ petition here. On the same measures, my lord, he filed DRT appeal. The appeal is pending. My lord, we issued a sale notice. Now the another AC has been filed before the DRT. He is challenging the sale notice. My lord, let him demonstrate before the DRT, my lord, that my measures are defective or against the settled proposition of law. DRT will consider and will pass the necessary order. My lord, he is doing forum solving. My lord, Varimadu's judgments, my lord is well aware of the Varimadu's judgment, the Supreme Court judgment. When the order is appealable order, he has already filed appeal, DRT. On the same day, my lord, section 14 has been dismissed, 13-4 has been challenged, section 14 also dismissed. My lord, what prevented him to file both the order and could file an appeal before the DRT and to get some orders? My lord, if he is not getting the order here, he can get the order DRT or the DRT. This is the forum, so that cannot be permitted in this matter. My lord, I am permitted to refer one judgment. I'm sorry, my lord, I'm permitted. My lord, let him challenge before the DRT. DRT will consider all the aspects. It is not on the question of delay. My lord, the para 34 and 34, it commences, my lord, and the Honorable Supreme Court has narrated of the Satyavati Tandon's judgments. Para 36, my lord, I will take my lord to para 36 of the judgment. Varimadu obeyed. Para 30. I am permitted to read, my lord, in this matter. In the instant case, although respondent borrower initially approached the debt recovery tribunal by filing an application under section 17 of the SARFAESI Act, but the order of the tribunal indeed was appealable under section 18 of the Act, subject to complaints of the condition and without exhausting the statutory remedial copy, the respondent borrower they approached the High Court by filing writ petition under Article 226 of the Constitution. We deprecate such practice, entertaining the writ application by the High Court in exercise of the jurisdiction under Article 226 of the Constitution, without exhausting the alternative statutory remedy available under the law. The circuitous route appears to have been adopted to avoid the condition pre-deposit contemplated under Section 18. So now, my lord, all the facts and circumstances have been discussed, my lord.
And the court has come to the conclusion that when the appealable order is there, my lord, the he has to, my lord, prepare an appeal. Appeal has already been prepared. Challenging the section 13(4). My lord, the section 14 is the offshoot of section 13(4). When the appeal is pending before the DRAT, now he is before the court stating that I have a question of law. DRAT will decide the question of law, my lord. If at all DRAT committed error while passing the order, if the order of the DRAT is arbitrary or exceeding the where settled proposition of law, all the my lord, things will considered by the DRAT. Under such circumstances, my lord, the writ is not maintainable. The secondly, as far as the sale notice is concerned, the essay has been listed today in the supplementary list, serial number 7. Let him
My
argue before the
submission is
DRAT
very
and get
simple.
the.
Very simple. 13(4) is a measure. That is possession notice. That I have already challenged. Without awaiting the appeal period of 30 days, when I complied the order passed by DRT to granting interim order of stay, without giving prior notice of 7 days, with an ulterior motive, under section 14, they have taken the possession of the property without giving any conducting merger, inventory, whatever, without giving notice. Here question is, the DRT is not deciding the matter on these measures taken under section 14. It's a ministerial function.
My lord.
It is followed by 13(4). Listen, let me complete, sir. Then afterwards you are going. My question, when the DRT did not appreciate the question of law, the act itself says the securitization and reconstruction of final asset enforcement of security interest. What is the security interest? To that extent, I may be permitted to only 2 pages I will take.
No.
Page number 179 and 222.
In respect to the very same proceedings,
Kanaya Lal's judgments, my lord.
2 essays were filed.
Yes.
On the same day, both the essays were dismissed.
13(4) and this 14.
4 and 14.
That is
Against
possession notice, is
13(4),
physical
against
possession.
13(4), you went to the DRAT.
13(4) only.
That's what.
Yes.
Why can't you go before DRAT against 14 also?
Why means, in the meantime, without giving an opportunity 30 days, waiting for the period, immediately a panic.
You have come before the court.
A panic will be there.
Nothing has happened.
Now
Then
possession has already been taken.
Yes, and the sale notice is issued.
Now today
That
we
is-
are challenging the sale.
That is so.
But now they have given one letter stating that within 7 days, if we don't ship all the household articles.
You better go before the DRAT and deal with all this.
My submission, this letter what they are given, if the period, at least 8 weeks may be given, not.
Respect of the same property, then respect of the same proceedings, different forums it cannot.
No, section 14 is different. This is a ministerial function. This is an order.
Why the DRAT will not, cannot decide that?
By that time, they're shifting, they seize everything. These are lapses they are committed. That is it. Otherwise, I would have comfortably.
When was the order passed? This
710.
order was
710.
710.
10/10/2020.
Immediately, why I filed on 28 means, sir?
What we do is, we'll give him a reasonable time to approach the DRAT. Till such time, don't do anything.
Yes.
No, we have already taken, we will maintain.
The same, whatever position
Yes,
as
that's-
on today, you continue with it. Let him go to DRAT.
As far as the possession is concerned, my lord.
Yeah,
As far as
possession only.
he is
Because
not
sale is
letting
different
me
thing.
to submit. my-
What I'll record is,
I-
you have
I-
taken the position.
Yes.
The questioning that is before this court.
Yes.
Yes.
You are in possession of the property. Let there be a status quo with
Yes.
regard to that for a period of 30 days.
No, your Lordship, because it will take.
My lord, already one appeal is pending in a
That is
13(4). You
separate.
could have taken
No,
this
then
day.
they will say section 14 is different, so 13(4) is different. Then.
Why should we? I am not granting more than 30 days in none of the.
Kanaya
any of the
Lal's
cases.
No,
judgments,
because
my friend is
I have
not
come-
aware of
no,
the
I have
Kanaya Lal's
completed the order passed by DRT 30. Now I have to prepare appeal.
For the DRT within 30 days.
No, your Lordship, then 30 days I'll approach. Let there be 8 weeks of status quo. 8 weeks.
That you will move before the DRT.
No, within 30 days, the matter will not reach Chennai because.
Already
the
appeal is
officers-
pending, one appeal. In that appeal, you could have given.
No, that is 13
Yes, my
is
lord.
different.
My
13
lord,
is
that
different.
is strange argument, my lord.
Then we'll do one thing, we'll say,
Yeah.
within 30 days.
Yes, my lord.
Let them approach the DRT.
Yes.
DRAT.
Yes.
And for another 15 days, that is for till 45 days, let there be status quo with regard to the possession that is taken.
Not sale. my
Removal
lord.
of the.
As far as the sale is concerned.
Sale is separate.
You are putting words into his mouth.
No,
which
no,
he
no,
is
no,
not
no.
asking.
But I'll know your DRT. You will go to the DRT and they will.
Not do that. Yes, please come. The present writ petition is filed seeking the following prayers. Prayer at page number 14. The facts of the case as stated in the writ petition are: the petitioner firm are into trading activities And the main business is procuring raw material from manufacturers. And in turn, distributing steel pipes and allied products to its various clientele all over the state. The petitioners have approached the respondent bank, have obtained the loan from the, how much is the loan? Nothing has been stated.
Now they are claiming 3 crores 76 lakhs.
Have taken the loan in which year?
2014. One second.
My lord, there are two loan, 6 crore 67 lakhs 50,000 and 90,000 in the year
Where from the court
2014.
has to read all this?
2040, my statement of,
The facts should contain all this.
nothing is there, my lord.
No. It's there.
Really there.
Sanction letter. Actually, huh?
Page number 9.
Facts.
Page number
nothing is-
90,
My lord, my,
Page number?
90.
90.
2014, 90. Annexure G, sanction letter we have mentioned.
No, your writ petition should mention
Yes,
all
yes,
this.
yes, ma'am.
The narration of events and all.
2014.
They have obtained the loan in the year 2014. And in the year 2020, they have approached the bank for restructuring of the loan. And the bank has restructured the loan account by substituting the rate of interest from 13% per annum to 10.45% per annum. It is stated that the surprise of the petitioners, rate of interest is not charged on fixed rate of interest at 13% per annum, but have charged on floating rate of interest, which is contrary to the loan agreement dated 38/2014 and 26/9/2014. The account of the petitioner is declared as a non-performing asset on 14/10/2024.
on
And
18,
demand notice was issued.
on 18/10/2024.
It says 14/10.
1410 NPA, 18/8,
On 18/10/2024, 13/2 notice was issued by the respondent bank. And later, possession notice was issued on 31/12/2024. According to the petitioner, it is not served on him. Then the petitioner had questioned the same before the DRT2 and by filing essay number 105 of 2025. Thereafter, the respondent bank had filed an application under section 14 of the Act for the second ACJM Bangalore, and an order was passed. And that's in criminal miscellaneous number 690 of 2025. Questioning the same, the petitioner has filed essay number 116 of 2025, dated 17/10/2025. The same day both are dismissed.
same day. both.
Yes,
The tribunal has dismissed essay number 116 of 2025 and essay number
105 of
105.
105 of 2025 were dismissed by orders dated 17th October 2025. The next part, the petitioner, as far as the order that is passed in essay number 105 of 2025, had filed an appeal before the DRAT, and the same is pending consideration. And as far as the order that is passed on, say, essay number 116 of 2025 is concerned, the petitioner is before this court by filing the present writ petition. The next part, the legal counsel appearing for the respondent bank submits that when the proceedings and the SARFAESI proceedings are initiated by the bank and against the proceedings under 13(4), when the petitioner has approached the DRT as well, questioning the proceedings under section 14, and when a common order, when two essays were dismissed on the same day, why the petitioner has challenged one appeal before one order before this court by filing writ petition and the other order before the DRAT is not known. It is submitted that petitioner ought to have approached the DRAT. He had relied on the judgment of the apex court in Varimadhu Obireddy versus B. Srinivaslu and others, reported in 2023 to SCC 168. He relied on paragraph number
36.
paragraph number 36. Relying on this, it is submitted that when there is an effective alternative remedy that is available to the petitioner, he cannot come before this court by filing this writ petition, and this court cannot entertain the writ petition in the light of the settled law. Next, Land Counsel appearing for the petitioner submits that though he has an alternative remedy of approaching the DRAT as he is on a question of law, and the measures that are interpreted and taken by the bank, the writ petition, as he is on a question of law, the writ petition is maintainable. It is submitted that without following the procedure, without giving the reasonable time, as stipulated under the act, the respondents have taken possession, and in fact
On 25/10, physical possession on 25/10.
25/10, 2025. 25. It is submitted that the articles of the petitioner are lying in the property. While the writ petition is pending, they have issued the sale notification, and questioning the said sale notification, he has filed essay before the DRT. That is
Essay number. Essay number, my lord. I have essay number.
It's listed today.
445.
445.
Sorry, my lord. 446 of 2025.
2025, and the same is listed today before the DRT. It is submitted that in the meantime, they have also issued a notice from the bank saying that if the petitioner is not going to collect the movables from the property, they are going to shift it to some other place. It is submitted that as a petitioner is on a question of law, the writ petition is maintainable, and the petitioner and counsel for the petitioners has submits that the court may hear the petitioner on the merits of the matter where the DRT has failed to consider all the legal aspects. Next paragraph. Having heard the counsels on either side, peruse the material on record. Against the proceedings under 13(4) and 14, 2 SCAs were filed before the tribunal, DRT, and both of them were dismissed by separate orders dated 17th October 2025. All the issues that are raised before this court can as well be raised before the DRAT. And in the light of the fact that against SA number 105 of 2025, already an appeal is filed before the DRAT. Hence, this court finds force in the argument of the counsel appearing for the respondent bank that the petitioner cannot come up before this court against the order under SA passed in SA number 116 of 2025. All the legal grounds that the petitioner wants to urge before this court as well be urged before the DRAT. In that view of the matter, this court is not inclined to entertain this petition. However, considering the notice that is issued by the bank that they are going to move the movables from the premises, and the fact that the petitioner is questioning the procedure that is adopted by the bank contrary to the provisions of the act, this court deems it appropriate to pass the following order. 1. The writ petition is dismissed, giving liberty to the petitioner to approach the DRAT within a period of 30 days from the date of receipt of the copy of the order. Number 2, the bank shall not shift I'll make it very clear. So instead of saying status quo, the bank shall not shift the articles in from the property which is in possession of the bank for a period of 45 days from the date of receipt of the copy of the order. Accordingly, yes, all IAS and so
Time spent for your lordship, the time spent here, challenging section 14 not from the essay.
The,
That may be taken into
anyhow, that he'll get the limitation.
Section 14 of the limitation.
The petitioner, will have the benefit of section 14 of the Limitation Act.
Great.
From the date of coming to this court.
Yes, my lord.
My one subject,
For 24.
my household bill, clothes are there, clothes,
My lord.
and daily use, clothes, books, that may be permitted to take. Everything they have seen.
Let them take, otherwise, tomorrow they will come and say
Immediately
that
without
material
hearing,
was
just
there,
like
this
that,
material is
all
there.
Family members.
45
their
days, my
clothes,
lord.
daily wear,
Oh,
everything.
anyhow, there can't be any problem for you
Yes,
if you take
Yes,
their.
please, basic necessity, my lord.
Do it, I think for that.
Basic
please,
necessity.
Please tell the bank,
Yes,
for that there need not be any order.
Yes, ma'am, please.
Yes.
Highly honorable. Great, my lord.
Hearing chair number 24, Anumesh HN for petitioner.
Yes.
Lord, the petitioner is, has been challenging the interim maintenance
How
order.
much is granted?
Around 8,000 has been granted, my lord.
What is your salary?
Salary is 35,000, my lord.
Then what is the difficulty?
My lord, in this case, even the respondent is, she is also a working lady, my lord.
Is it any material on record with regard to her
No, my lord. In
employment?
this case, my lord, the guidelines of Rajneesh versus Sneha has not been complied, my lord. Both the parties has not filed the assets and liabilities. Even trial court has not.
You cannot come before the court saying that when you have not followed. So let's see, because 35,000 and your income 8,000 that is granted, we'll see once the other
My
side
lord, even
comes.
she respondent also earning more than 45,000, my lord.
But that's not there on record according to you. That is not there on record. How can we consider your submission? Let them come, we'll see.
She has suppressed.
We'll ask them to file an affidavit when she comes. The learned counsel for the petition is permitted to take out hand summons on the counsel appearing for the respondent.
My
This
lord,
is matter of
trial court has issued the FLW, my lord, in this regard. That's the reason, my lord.
It will, if you don't pay. This is matter next week. If you file the memo, I'll hear it.
Please, my lord.
Yes.
Chair number 25, Hari Prasad.
Appealing for petitioner, your lordship. I have challenged the order dated 19/9/25 where my IA for recall and reopen of PW1 was rejected.
Where is that order?
Annexure A, your lordship. Page number 12.
Yes.
Only 3 opportunities was given to me.
Why, how many minimum opportunities are required? GNWC is of the year 2015. So it is a 10 years old case. So please now come to the order.
The petitioners, the chief was closed on 24/9/2024, your lordship. It was
Let's
posted
see
for-
your affidavit, your petition seeking reopen. Where is that?
Application 21.
20?
21, 22 is the affidavit.
Yes.
Yes, your lordship.
Let's read. Why you want
Para number 3. For the submitted on 3/7/2025, the case was posted for cross-examination of PW1, and on the morning session, the counsel placed time for cross-examination of PW1, but was kept aside, and case was called again at 12:35 p.m. By counsel seeks time, learned counsel for petitioner seeks time to pass over as the petitioner was not present in two rounds. So again, it was passed over. Later, my client went to attend some other court. In meanwhile, at 1:53 p.m., the matter was called and posted the above for respondent evidence on 22/7/2025 by taking cross-examination of PW1 as
I've seen. Please come to the order now. Paragraph 6, read.
The petitioner has filed this application under section 7, 10 and 17 of Guardians and Wards Act. Respondent to appoint and declare him as the guardian of the person and property.
Come to
of
paragraph number 8.
Yes, Your Worship. The petitioner has contended that the respondent is trying his level best to delay the trial and the case is of the year 2015. He has successfully dragged it for 10 years and the very purpose of the case is lost because of the inordinate delay. It was dragged by the petitioner. Inordinate delay, the respondent has deliberately not done the cross-examination of PW1, though given or repeated opportunity. His counsel did not turn up after getting the case passed over, hence prayed to reject the application. On basis of the order, it appears that on 8/11/2024, 6/1/2025 and 4/2/2025, the case.
So that is a span of how many months? 11, 12, 1 to 4 months.
On 8/11/2024, PW1 was absent, Your Lordship. On 6/1/25, in the first round he was present, the counsel was present, but when it was passed over, he was absent. And again in 4/2/2025 also, in the first round they were present and the second round when it was called.
Then what are you doing for an application from 4/2/2025 till 19/3/2025? when that passed over and it is taken as nil,
Hmm.
you were waiting till for more than 1.5 months to file this application.
Application was filed on 23/4/2025.
23?
4/2025.
So that is after 2 months. Court says it is 19/3/2025. On 19/3/2025, the Learned Council has filed I number to reopen the case for the purpose of cross of PW1.
Your Lordship, the petitioner has merits.
But who stopped you from doing all this?
Sufficient
No,
opportunity.
they have also, because this is a Bangalore, I think it's a family court Bangalore.
Yes.
They have to complete this case by December 15.
Your Lordship, they have taken 7 years for completing their evidence.
No, court has passed orders to complete all these 10 years old matters by December 15. So they have their own urgency. If you don't cooperate, what they will do?
Will further cooperate, Your Lordship. An opportunity to be given for the petitioner to cross-examine, Your Lordship.
As per the order dated 3/7/2025, it is specifically held, the respondent shall not seek further adjournment for the purpose of cross of PW1 when both the parties shall cooperate for speedy and timely disposal of the petition. In spite of sufficient opportunities granted to the respondent side to cross-examine PW1, though the PW1 is recalled and in spite of presence of PW1 before the court, the respondent side has not cross-examined PW1. This conduct of the respondent side clearly reveals that only with the malafide intention to protract the proceedings, these applications are filed. The court cannot assist the party who is not coming to the court with clean hands. Yes, notice to the
Your
respondent.
Lordship, it might be stayed, Your Lordship. On 12/12, it is posted for arguments, Your Lordship. Kindly state, Your Lordship. It is posted
The
for
petition
arguments
is
on
from,
12/12.
I will
Your
not
Lordship.
stay any of the proceedings. And that too, this is not a case. The petition is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect. Once memo is filed, list the matter.
Cell number 26, Aditya D.
Your Lordship, I number 19, I have filed another petition. It might be connected.
Where is that?
The number,
Serial-
WP number 36195 of 25.
36195
of 25.
It is not there in the list.
It is not clubbed yet.
No, is it listed?
No, Your Lordship. It is
Then
not
we will
listed.
see when it comes. List that matter on Monday. Give that number so that we can order notice in that also. Huh. No, this won't come. Only that matter will come on Monday. Yes. Yes, next.
Cell number 26,
Yes.
Appear for the petitioner, my lord. My lord, petitioner is the wife, my lord. The petitioner is before this court challenging the order passed by the family court, deferring the order of maintenance sought by the petitioner, my lord. The marriage between the petitioner and the
Rejected.
it's not rejected, my lord. They're deferred it until for evidence. And I've sought for maintenance, not for myself, but only for the minor children.
Notice.
My lord,
cell number
Hand summons.
27,
Lord, the reason for deferring is that the evidence has to be concluded for granting maintenance. It is not a reason,
Let the other side come, we will pass order.
Lord, some interim maintenance.
No. That kind of orders I will not pass. The same notice, the person, hand summons. Yes.
27.
And someone's on the council before the trial. Please.
Whenever you file the memo, it will come next day.
Please.
Yes.
I'm challenging the maintenance award, my lord, and the.
How much is awarded?
My lord, 9,000 is granted.
What is your salary?
My lord, I am a village farmer, my lord, I am not having a salary.
There must be something.
My lord, earlier, my lord, I am working.
Please come to the order.
My lord, page number 28, the order. my lord. 5,000 is first petitioner and 4,000 is child, my lord. They are residing in the village.
Your general monthly expenses are 30,000.
No, my lord, I am not like that.
I am saying from your own statement, read paragraph number 13. On the other hand, the respondent in his affidavit of assets and liabilities disclosed that he is residing at his parental home and his monthly general expenses are 30,000.
My lord, they are They are joint family members.
To loans of 10 lakhs from his relatives.
They are family members, my lord. We filed the 13-1 application, my lord, for seeking divorce for arising movement. Thereafter, my lord, she filed an application for maintenance, and they have shifted the family to village to from town, my lord. Now, my lord, the petitioner is suffering from liver problem, my lord. Thereafter, he is hospitalized and then is lost the job. Now, the my lord is residing in the parent house, my lord. Before filing this, my lord, we are conduct the conciliation both the parties, and they are residing in separately for more than 5 years. Thereafter, my lord, they have cropped up some another allegations. She is left the house, my lord. Thereafter, he is suffering from various problems in
What
the
about the
stomach.
child? Who will take care of the
Child for 4 years.
Who will take care?
Mother is taken.
Then
Blood, we are ready to pay 4,000 because unable to bear the other cost.
when counsel appearing for the petitioner submits that the court has granted 5,000 to the wife and 4,000 to the child. The petitioner is unemployed, suffering with liver ailments. As such, he lost the job. The court, without considering all these aspects, had granted an amount of rupees 8,000. Considering the submission, there should be stay of all further proceedings on the condition that the petitioner shall pay an amount of rupees 2,500 to the wife and 2,500 to the child by 5th of every succeeding month.
4,000.
Arrears also at the same. Within 12 weeks.
Grateful.
Notice, same, the hand summons to the counsel appearing for the respondent and shall file a memo to that effect by give some date in January. If not, the stay granted by this court stands vacated.
Cell number 28, CG Malail.
My lord, the petitioner is challenging the interim order of visitation, my lords, whereas the interim application has been partly allowed. The
notice,
my lords, the reason is that Christmas vacations are coming since September.
Notice, we will take this side of the vacation. In this child custody matters, I will not pass any ex parte order without hearing the other side.
My lords, maybe I may be permitted to
Yes,
serve it on
hand
the.
summons, same order. Whenever the memo is filed, this is the matter.
Cell number 29. Vaishali Hegde.
This is the matter, my lords. The petitioner is the husband before the trial court. The lordship sees the order dated 28th October 2020.
What is its maintenance order?
No, my lords. Your lordship recalls in the last month, the wife had filed a petition seeking that the issues were not framed with regard.
Yes.
That matter, my lords. There are 2 IAs filed by my lords. One filed by the petitioner husband and one filed by the respondent wife. Both the IAs filed by the parties was rejected by the trial court, saying that there was a direction by the Honorable Court to dispose of the matter within 6 months. Such being the case that the Honorable Trial Court rejected both of our IAS matters. That IA was challenged before lordships in WP number 6286.
I remember. I said deal with it
please,
at the time of passing.
Please, and your lordships are granted 6 months time to dispose of the matter. When my IA number 24, my lord, seeking summoning of the medical record from the hospital, my lord, was rejected. On that application, I'm before your lordships, my lords. For a moment, my lord, your lordship sees the observation made by the trial court, my lords. Page number 29, my lords, of the impugned order. Running page number 29, ink page number 6.
MC of 2021.
Please, my lords. For a moment, my lords. Page number 10 is the paragraph number 10 and 11 is the relevant part, my lords. I permit to read. Admittedly, petitioner has not invoked the ground of adultery enshrined under section 13 clause 1 clause I of the Hindu Marriage Act. No doubt there is a pleading in the petition regarding extramarital affairs and medical records to show that she has been taking to avoid.
You want why you file this application?
Please, what happened, my lords?
Come to your affidavit.
Please, my application.
Support of the IA.
Please.
Where is that?
That is at annexure K, page 111, my lords.
Page 111.
Please, 111, my lords. I filed this IA only after confronting the document at the cross examination. After completing, please. Page 111, my lords. Annexure K is my annex. Please.
Yes.
Please, may I read the IA, my lords. That for the reasons shown accompanied, the petitioner prays this honorable court may please to direct issue summons to Dr. Sangeeta Rao, Sita Raksha Clinic to produce medical records dated 18.
You are for the husband.
Husband, my lords. I had obtained the documents which were under the custody of the respondent wife. When I got to know about the medical records, she had taken the original documents with her. That was confronted during the time of cross-examination. She admits the contents of the documents, but she says that she's not under possession. Subsequent to completion of my cross-examination, my lord, immediately I filed this application seeking summoning. So that because my documents were marked subject to proof of validity under secondary evidence. So in order to prove that the respondent wife has committed an adultery, I am sought this application, filed this application seeking the doctor to come and give evidence on that document, my lords. So this is, your lordship,
How is you filed the, who is he? You have, the MC is filed on what ground?
cruelty, my lords.
Hmm?
Cruelty, my lords. Not on adultery. For the reasons that, my lords.
Cruelty.
Please, cruelty,
And,
my lords.
why these medical documents are relevant?
My lords, this for reasons that, my lord, this is amount to a mental cruelty on me. For the reasons that.
What did you say in your, let's see your
Petition. I'll tell my, I have my petition. Your lordship, may kindly, my annexure B, my lords.
Page number, where did you, which paragraph you have
Please, my
stated
lords.
so?
Paragraph 14, my lords. Page 35, paragraph number 14, my lords.
Yes.
It is submitted that the petitioner has found the medical records of the respondent in the cupboard and was shocked to know.
Paragraph number 40?
14, my lords. Page 35, my lords.
No, it's not 35.
35. Paragraph number 14. It is submitted that the petitioner has found the medical records of the respondent in the cupboard and was shocked to know that she was pregnant in the month of February 2021. The respondent as having been extramarital affairs since 2019 as per the medical records, which proves that she has been taking contraceptives. In fact, the petitioner has been physically apart from the respondent since over 6 years, and it is very strange that she became pregnant meanwhile. The medical record shows that respondent got inserted property which works as a contraceptive, and the petitioner has looked into the family planning methods as per the respondent's medical records dated 21/1/2020. This clearly discloses that the respondent is having an extramarital affairs after marrying the petitioner. It is submitted that the medical records for the respondent without knowledge of the petitioner reveals the following so and so so and so. It is next paragraph number 16, my lords. It is submitted that respondent has cheated the petitioner all these years and mentally and physically tortured him. Due to the said act of the respondent, it is impossible to continue to stay with her. So I had the medical photocopies of those documents, which has been confronted. Now, for a moment, for the cross-examination, my lords, interestingly, my lords, for a moment, the cross-examination, my lords, because I have filed this application subsequent to the completion of my cross-examination, your lordship may come to page number 106 of my cross-examination. That is annexure. And she admits that subsequent to the birth of the first child, there is only one child, there is no physical relationship between the parties. She is admitted in the cross-examination. Now the relevant part, if your lordship, I could also take to that admission as well, my lords.
Page number?
Page number 45, my lords. It is true that, lordships gets it, my lords. Paragraph number, second paragraph. It is true to suggest that exhibit P10 medical document of Sita Pateja Specialty Hospital. My name is visible in the column of the patient's name and also shown as wife of Mr. So-and-so. I do not know the mobile number mentioned in exhibit P10. In the said document, treated doctor name is shown as Dr. Sangeeta Rao. I do not aware about the treatment mentioned in exhibit P10. As per exhibit P10, the date to visit is 21/1/2020. It is true to suggest that it is written in exhibit P11 medical records that the treated doctor name is Sangeeta Rao. Now, interestingly, Malo, the first child was also born in the same hospital, and she is admitted in the cross.
Where did she say that there was no physical relation?
Please, please, my lords. Please. Page 95, my lords.
95. Yes.
In the middle paragraph, my lords, it is true to suggest that your lordship should get it. It is true to suggest that subsequent to birth of our son, Kian, we both were staying at Coxton, Bangalore till March 2015. It is true to suggest that in the March 2017, we shifted to Langford Road, Bangalore. It falls to suggest that so and so. Then Page 95, my lords. The third line. Third line. It is true to suggest that after birth of my son, there was been no physical intimacy between me and.
Yes.
And your lordship says allowed the said IAF, the petition filed by the respondent wife to reconsider the IA, my lords. My humble submission is that, my lords, I request the honorable court to set aside the impugned order and let the matter may be reheard and pass appropriate orders by the trial court as done in the other IA, my lords.
Other side has to come.
My submission, my lords. Please, my lords. I'll take out hand summons on the respondent, my lords. Wife. I have next week itself, my lords. I will serve the copy today itself, my lords.
The petition is permitted to take out hand summons on the counsel appealing to the respondent. This is the trial court. And shall file a memo to that effect. Once the memo is filed, list the matter.
Please, my lords. Oblige, my lords.
Cell number 2030. Rohan Kotari.
Yes.
An ad interim ex parte order granting anti-suit injunction on the wife's suit restraining the husband from proceeding in German court proceedings concerning custody, where she has herself participated for more than 2 years. The trial court passes an order, no reasons, no consideration of anything.
Let's see that order.
Your Lordship, Your Leadership. The impugned order is dated 10/10/25 at page 35 of the petition.
30?
35, Your Lordship. Para 2 onwards. Peruse the record filed in respect of IA number 3, filed under order 39(1) and 2, seeking ad interim temporary injunction ex parte, restraining the defendant from continuing or participating with custody proceedings before the court, which is the High Court in Germany, bearing case number so and so. Since at this pre-trial stage, the sworn testimony and the petitioner and the document produced revealed case, the petitioner has prima facie case, and balance of convenience lies in her favor. And if
the husband is staying in Germany.
Husband is staying in Germany, petitioner and respondent were both residing in Germany for many years. Daughter is born in Germany. Daughter is a German citizen. Daughter has a German passport. Till 2 years, the daughter was in Germany. She was forcibly removed from the German jurisdiction in contravention of a German court order on the basis of proceedings that she had herself initiated in Germany.
Did she say so in her petition?
She does not even disclose this in her plaint. In the
that order.
Your Ladyship. Your Ladyship may see page 116 and 119, 129. Actually, may I take Your Ladyship from the date on which the proceedings in Germany began? Page 58, she files an application before the Weinheim District Court saying that she wants to move the home of the child. In Germany, the proceedings are, if you want to move from one jurisdiction to the other jurisdiction, you have to register in the local child welfare office. So she starts with that. The court issues notice to me on her petition at page 64. I'm just taking Your Ladyship to the translated copies because the German documents are in the German vernacular.
It started in 2023.
2023, February 2023. Court issues notice on her application. Your Ladyship sees at page 64, Weinheim District Court, proceedings bearing 3F25 of 23. An application for an interim order received by the court will be sent as an attachment. This is a notice sent to me. Pursuant to notice sent to me,
So
both,
as well move the court seeking vacation of this order.
Your Ladyship, I can of course move the court for seeking vacation of this order, but Your Ladyship retains writ jurisdiction when there is an abject non-exercise of any basis.
No, because all the aspects were not stated.
Yes,
the court has granted the injunction.
Yes, Your
So you can as well file an application to vacate it.
Your Ladyship may just see the order. 39 says two things. 39(3) says two things. When the trial court is intending to pass an ex parte ad interim order without hearing or giving notice to the other side, they have to, number one, record reasons. Number two, they have to have the matter disposed of finally.
Tell the court that what you've done is wrong.
Your Ladyship.
Because you can as well, like the other party is already there. You file your vacate petition, the court will hear it. Why should the High Court hear this? Because there is an option for you.
There is of course an option, Your Ladyship. I'm coming to Your Ladyship's inherent jurisdiction because there is a abject failure of exercise of jurisdiction by the trial court. And in fact, a order from this court.
When is that? When the matter is directed to be listed again?
Your Ladyship.
When the matter is directed to be
6th
listed.
January. He passes the order on 10th of October and puts 3 months. The provision itself says within 15 days you have to dispose of the matter. And in fact, the requirement of law is as soon as you've got an ex parte injunction, you have to notify me. They don't even notify me. I obtain copy of the order 20th of.
What happens is, again, now interfering with this order, asking issuing notice to the respondent, again, keeping it pending. Instead of that, you can straight away have an order from the trial court. That's the easiest way.
Then
for
your
the
leadership, may I
parties.
request one decision? If your leadership could pass an order, if the court requires issuance of notice, but the suggestion I'm making, even notice may not be required. Let my matter be disposed of with the direction that the trial court shall dispose of this matter expeditiously, preferably before this side of the vacation.
Yes. The petitioner is before this court, agreed with the orders passed in I number 3, whereby the court had restrained the petitioner herein, who is the defendant in the suit, from continuing with participating or prosecuting the custody proceedings before the court at, how do you spell it? Karlsruhe, Germany.
Karlsruhe, Germany.
Karlsruhe, Germany, bearing case number 16 UF 155/2024. Till he appears and file objections to I number 3. Then counsel appearing for the petitioner submits that while granting ad interim injunction, the court has to give proper reasons. Court has to satisfy itself about the necessity of granting an ad interim injunction. It is submitted that the order is bereft of reasons. It is further submitted that, in fact, the wife, along with the child, was residing in Germany. And in fact, the wife had initiated the proceedings in Germany. And contrary to the orders of the courts at Germany, she brought the child to India. When there is clear separation with all, when an injunction is sought, the person has to come to the court with clean hands. It is submitted that this is a case where there is clear suppression and misrepresentation of facts. Hence, the order impugned needs to be set aside. Next paragraph. Having heard the counsel for the petitioner, there is a material on record. Whether when an order is passed by the court granting injunction, if the petitioner is aggrieved by the same, he has a remedy to file a vacate petition before the very same court. The petitioner has raised several issues. At this juncture, this court is not inclined to go into those aspects. This court deems it appropriate to dispose of this petition with the following directions. 1, the following order. The petitioner, you have to serve the copy on them.
Yes,
The
I serve it on
petitioner
counsel.
shall serve whoever, the petitioner, defendant shall serve the copy of the vacate petition on the counsel appearing for the respondent plaintiff by 9th of December. 9th of December, and the court shall dispose of this matter. The family court is working till
20th.
Only.
Yes.
And so, by before this side, they shall dispose of the matter. This side of dispose of the IA. This side of the vacation.
I'm obliged.
As no adverse orders are passed, the notice this court is not proposing to issue notice to the respondent.
Cell number 31, Priya P for petitioner, Tejas Roy K for Kavita.
For the petitioner, my lordship, I filed challenging e-auction dated 27/11/25, my lordship. I am the title holder and the guarantee.
27/11.
Yes, my lordship.
It's already over.
Yes, my lordship. The sale, whether sale is done or not.
No, whether it is done or not. Let's see your prayer.
Yes, my lordship.
Quashing the sale notice, no, that we will find out 1111. Declare the SARFAESI proceedings initiated by respondent number bank as null and void for on of mandatory notice under section 13(2). Not to proceed with the auction. To produce valuation report, direct bank to produce detailed statement of accounts, grant liberty to the petition to approach the DRT for redressal, direct the registry to club tag this petition with WP number. These are all the prayers, sir.
My lordship, the thing is.
How can you seek these kind of prayers?
My lordship, writ petition number 30071.
No, that you can make a submission before the vote. That can't be a prayer. Prayer
my
would be like substantive prayer should be one or two, not these many.
Yes, my lordship, but the reason here I'm
What
stating
happened when
this.
auction is conducted?
I appear for the respondent bank, your lordship.
Auction conducted?
Action conducted, property already sold. Bidder already deposited 25% amount. Your lordship.
Then I'm seeking direction to go before the DRT, my lordship.
You don't require a direction. You can go before the DRT provided
My
it is
lordship.
in accordance with law.
Let the sale took place may be recorded in the order sheet. ma'am.
Yes. The writ petition is filed questioning the sale notice dated 11/11/2025 issued by the respondent bank and also to declare the SARFAESI proceedings initiated by the bank against the petitioner's property as null and void. It is the case of the petitioner that no notice is issued under section 13(2) and rules 3, 8, 9 of the rules. It is also stated that the bank has initiated the SARFAESI proceedings and also the sale notice without following the procedure as contemplated under the SARFAESI Act.
2022 we issued notice, your lordship.
Hmm?
We
So that's
issued
their
the notice.
contention. It is stated that the repeated issuance of sale notices, first dated 15/9/2025, then dated 11/11/2025, and earlier notices are withdrawn without serving statutory notice under section 13(2) and without complying with rules 8, 6 and 9(1), demonstrates that there is malafide intention on the part of the bank, non-application of mind. It is stated that the cause of action arose to the petitioner on 15/9/2025 when the respondent bank issued the first sale notice, and further cause of action arose on 11/11/2025 when another sale notice was issued. Hence, the petition is before this court. When counsel appearing to the respondent bank submits that as per the sale notice, the auction was conducted on 11/11/2025 and the auction purchaser has paid the 25% of the amount. It is submitted that they have followed the procedure contemplated under the SARFAESI Act, and in fact, a notice under 13(2) was issued in the year 2022.
Yes.
In the year 2022, and there is no irregularity. It is submitted that if the petition is agreed by any of the action of the bank, the petitioner has an effective remedy before the DRT, but he cannot come before this court, and the writ petition is not maintainable. Next para. The writ petition is filed questioning the sale notice, and already the sale is conducted. If the petitioner, and as such, the writ petition has become infructuous. If the petitioner has any claims about the manner in which the SARFAESI proceedings are initiated by the bank, the petitioner has an alternative remedy before the DRT, and hence this court is not inclined to inclined to pass any orders in this writ petition. Accordingly, accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to approach the DRT in accordance with law.
Still number 32, Sanjay Henayan, for petitioner.
The petition filed by the wife. All that I'm seeking is a reasonable direction from this court to dispose of the matter in about 6
What
months.
is this?
It is a family court in Bangalore.
I mean,
The second
Second
I
additional.
think it's the second.
And MCs of which year?
MCs of the year 2022, your lordships.
That can't be, because only they have to, now the directions priority is still 2019.
Reason, 6 months, 1 year, whatever time, lordships.
That you will come in the month of February, we'll have a meeting in December.
The only thing, lordships, because I'm not seeking it except for a divorce and for
But
custody.
please understand,
Understood.
now there are so many matters pending from 2013-14 also in family courts. So we have decided that they will dispose of on priority till 2019.
1 year time, lordships. 1 year is sufficient for them.
Let this, once
Because
2019.
6 times they've taken adjournment.
2019, no, once 2019 is completed, now the next target, in that if your matter falls within that, we will do. What the judges are saying, now we say dispose of 2019 matters, whenever somebody files a writ petition, we dispose it off, saying then that becomes a problem to them.
So we'll kindly see, it's been 6 times she's come for
When a
cross-examination.
writ petition is filed, seeking a mandamus, directing the trial court to dispose of the matter as expeditiously as possible. This matter is on the file of the principal, on the file of the second additional judge, family court. This MC is of the year 2022. The specific directions are issued to the family courts to dispose of the matters till 2019. In those circumstances, this court cannot pass an order to the, give a direction to the family court to dispose of the matter which is of the year 2022. Hence, this court do not find any reasons dismissed.
Lordship, at least give me the liberty to file it after. If there's any more delay, at least if this is brought to the notice of the court, they will at least.
The petitioner can renew his request at a later point of time.
No, at least if this is brought to the notice of the family court that that you have, at least expeditiously. At least I'm saying
No, they
as
will not,
expeditiously
they
as
will
possible.
not conduct the trials now of the other
No, I'm
cases.
not asking for 6 months. At least Lordship says as expeditiously, something will be there for the family court. Otherwise, 6 times, 7 times, they're granting adjournment for cross.
They will not do it once the.
Lordship,
once
you
they
kindly see the
complete this.
contract. I will show the thing. 6 times they've granted.
They will grant now because they are not going to proceed with the matters of 2022.
At least an expeditiously, something the court will,
Let's not create any confusion to the judges. Yes.
Still number 33, Abdul Jabbar M for petitioner.
Appearing for the petitioner, your lordship, I'm a sale auction purchaser. The sale certificate came to be
Please,
issued.
Mr. Vignesh Shetty, serve notice on it.
Please, your lordship.
The Mr. Vignesh Shetty is directed to take notice on behalf of the respondent bank. Then counsel for the petition serves the copy of the writ petition on the council and list this matter on 10th of December.
Grateful, your lordship.
Still number 34,
Yes.
Vaidyana.
My lords, I appear for the petitioner, my lords. My lords, I have challenged the e-auction sale which is going to be held on 9/12.
Appears with the
my lords.
ICICI.
My lords,
Council who appears.
my lords, Nandish B. Patil, my lords.
Nandish?
One second. Nandish Patil, my lords.
Mr. Nandish Patil is directed to take notice on behalf of the respondent bank. The petition to serve the copy on the council. This is a matter on
My lords, Tuesday is the auction sale, my lords.
Monday. Give him
We are
the-
ready to deposit 50 lakhs, my lords.
I will not grant that kind of order. Please give notice, serve notice on him. It will come on Monday. If you serve to today, then only I'll hear on Monday.
Please, my lords,
To
I
the
will serve
council,
it. Please.
in the name of the council. Yes,
Still number 35, Sridhara K.
Petition.
yes.
The action should be going to be held on 8/12/2025. ma'am. Even after notify the NPA, we have deposited 28,92,000. ma'am.
What is outstanding?
They were 23 lakhs, my lord. We are ready to deposit within 6 months entire amount, my lord.
6 months is a long time.
Because there was a family dispute, as husband and
That's
wife.
true. For
4
that
months
amount
maybe,
we can
4
deposit.
months time may be granted, will
Who
deposit.
appears for the bank?
Indian Overseas Bank.
Indian Overseas.
Even after notify the NPA, we have deposited the 28 lakhs. ma'am.
Auction is on 9/12.
8 will, ma'am.
9/9, you said so.
Yes, ma'am.
9/12.
Yes, ma'am.
Which, who appears for this bank?
We'll ascertain, ma'am.
Hmm?
We'll ascertain.
No, Mr. Sivan.
If you serve the notice on the bank council, then we will take this up on Monday
Please.
and pass orders. Indian Overseas Bank, no. Who is there? No bank councils are here.
I don't.
You tell the court officer.
Please.
The so-and-so is directed to take notice, like he will give the name,
Please.
of the respondent. Council, the list is matter on Monday. By that time, the council for the respondent shall get instructions.
For admission, serial number 36.
My lord,
Yes.
respondent has filed an appeal before division bench, honorable division bench. The same to be
It is
connected.
submitted that the connected matter
Double
filed
two-
with the insurance company.
2278 of 25.
So insurance company is pending before the division bench. List along with so and so.
Serial
Then
number
37.
37. Shri Padvi Shastri.
I appear for respondent.
Admit file hearing
No,
TCR.
there is a question, there is a question of law involvement is there. The claim petition dismissed in the before the tribunal
Hmm.
or stating that the P report filed. There is no negligence of the case.
That's
So,
what, that will be decided.
well, admission, it is a first work at adjourn as a admission.
Admit.
Call for the, instead of admit, call for the TCR.
Yes.
This is in the month of March 38.
Serial number 38.
I'm appearing for
Ananda.
appellant in this case, Your Honor. Case of injury, my lord.
Yes, admit file hearing TCR
My
39.
lord, kindly refer the matter local.
The request of both the parties, matter is referred to the local adala. 39.
39.
Same matter, same.
Yes, 40.
Serial number 40.
Case of injury for claimant appeal, my lord, for enhancement.
Admit.
Memo for dispensation.
No, it's coming up, notice to the respondent.
Memo for
Notice
filing.
for whom?
R2, my lord.
Memo is for taking dispensation of notice to R2 dispense with notice to the other respondent. This 41.
Serial number 41. ST Bhagwan.
125 application. Lord, on the civil side, I have been paying regularly at the rate of 8,000 rupees per month.
Where is the respondent? No representation on behalf of the respondent. Counsel for the petition is present. Is this matter after vacation?
Serial number 42. 42.
I
Gurudat.
appear for respondent.
How can you
But
make such
yesterday-
a submission before the court that you have informed him?
Lord, we had informed him, Lord. Yesterday, Lord, the moment we took an adjournment saying that, Lord, we undertake to inform the respondent.
Not undertake. When I asked, you said I have informed,
It's my colleague, Lord.
whoever it is. That's not fair.
We have informed him.
I never said you will. I said, have you informed? Your colleague said, we have informed. I will never allow anybody to say, we will inform. If it is we will, it will stay in the list like that. Because it is inconvenience to the other side, not right.
Yes, Lord. But, Lord, after me, I'm sorry, Lord, for that, Lord. Immediately, Lord, it has been informed to the council, Lord, through a call. They didn't pick up the call. We have messaged him, Lord.
Argue.
Lord, in this matter, Lord, I have been informed by, Lord, the trial court council that, Lord, the matter is, Lord, is in the verge of settlement.
Is it so?
I have no intimidation from you.
Even I spoke to the trial court council counterpart
Kindly-
also.
If that is so, kindly post on 10th, because I only myself will move this. On
Then
11/11, I
counsel
filed a
the-
memo for,
Submits that the matter is at the verge of settlement. Counsel the petition submits that he has no instructions. This is matter on 10th.
10th, my lord.
10th, but I'm not
It's not possible. We'll have it on 13th.
13th, much
Lord,
obliged.
I'm for the. 10th.
13th.
It may be called an after vacation, Lord.
After vacation?
After vacation, it may be called.
Because interim order has not been passed, my lord. No, the interim maintenance is paying to me.
Yes. Now list the matter on 17th.
17th, much obliged.
Yes.
Serial
Next.
number 43.
Yes, madam. This is the husband's petition, madam. The respondent wife filed the maintenance
What is the interim order?
seeking interim order of stay
What
of
is the order granted by the court?
5,000 rupees per month. It's a agricultural laborer. And she also filed a partition suit. And he had 3-4 sisters also there. On the other hand, the 1992 marriage,
5,000 is a very meager
and
amount.
your last, may kindly me to make two more lines. 1992 marriage, my lord. 2023 petition filed for maintenance. She left in the year 1996 itself after giving birth to female child.
Where is the child?
Already both the children are attained their majority. She is also living with her daughter. She is earning in the discharging her duties in the bank also.
So after lapse of long time, she filed partition suit as well as maintenance also. So she also living with, I should not bring it to her lordship that she is also living with somebody else. And he also got marriage with, and for the second wife, he is having two children. He has to, Marat?
What is to be done now?
My submission is that 1 lakh it will be held, 1 lakh arrears of maintenance, out of which 50% I am myself making submission that.
That is
Subject to
at
that.
5,000.
My lord?
At 5,000, it would be 1 lakh arrears.
No, 2 years is there.
That's what I'm saying. You are
Please.
saying that arrears would come to 1 lakh.
Yes, ma'am.
Calculating at 5,000.
Yes.
Hmm.
So for out of which I am paying, depositing 50,000.
And per month?
Per month, same, with the same calculation, I will, in furtherance, I will pay it. Ma'am. Yes, madam.
So every month you will pay 5,000.
That's there, madam.
No, that's what I'm asking you. You will pay 5,000
Yes,
and
ma'am.
50,000 towards arrears. Is it so?
My lord, thing is, ultimately that order would be in force, madam, because no order will not be get because of that only 5,000 has been awarded. It's an agricultural labor. Let them come before this honorable court. Let them
Please
decide.
come. Then counsel for the petitioner submits that. The marriage had taken place?
My lord,
Which year is the marriage?
1992, my lord.
The marriage has taken place in the year 1992. And when she left?
See, after lapse of 3.5 years.
After lapse of 3.5 years, she left.
Yes.
The daughter, in the wedlock, they're blessed with a daughter, and she has also attained majority. Land council submits that he is agricultural labor, and the court had granted 5,000, which is difficult for the husband to pay. Considering the same, there shall be stay of all further proceedings on the condition that he shall deposit an amount of rupees 50,000 as part of arrears within 8 weeks from the date of receipt of the copy of the order, and shall
Yes.
continue to pay 2,500 per month.
Please, madam. Bless.
Notice to the respondent.
Please.
44.
Yes.
Suresh.
In this case, I am for the petitioner, my lord. The order dated 10/10/2005, my lord. 25.
What is the
possible-
amount granted?
7,500 per respondent number 192 each, my lord, and 30,000 with the annual raise
10,500 each.
each.
So it's 15,000.
15,000. And my lord, 30,000 per annual educational expenses of the child. Child is only 2.5 years. My lord.
Child is aged about?
3 years, about 3.
What is your salary?
Salary is no salary, my lord. No salary. I am depending the father house.
Let's see, what did the court say?
Kindly see the assessment liability.
He has stated that his father has invested 30 lakhs to establish silk saree showroom.
The false allegation.
Hmm?
False statement given before the court.
He has stated that.
My affidavit in assets and liability, my lord, page number 68.
That is, you have stated, somebody else have not stated. Come to paragraph number 23, you read it.
23. Income of respondent is concerned, it is elicited from his mouth that he studies up to PUC, is working as Herbal Life. Only member he has category admitted ID number. ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಆಕ್ಚುಲಿ ಅವರು PUC ಈಗಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇಲ್ಲ ಅವರು. ನೋ, he left the job. He is earning income, however, no document furnished regarding the extra income received by him. No proof of income. I mean, PUC, I am studied in PUC.
Please come. Then counsel for the petitioner submits that without there being any evidence, the court had granted maintenance of 7,500 each to the wife and the child, and further directed to pay educational expenses of 30,000 per month. It is when the petitioner has no income and is depending upon the father, the court, without appreciating the evidence and appreciating the evidence, had granted the exorbitant amount as maintenance. Further, the court is also directed to pay the litigation expenses of rupees 25,000. Considering the same, they shall be stay of all further proceeding on the condition that the petitioner shall pay an amount of rupees 4,000 to the wife and 4,000 to the child. That is 8,000. And
The 3,000.
8,000.
No income.
8,000, and shall continue to pay the educational expenses at 10,000 per annum. Notice to the respondent.
And number 46. Hemalata V.
For petitioner, your lordship, I'm challenging the order of visitation rise IA number 8, your lordship.
Where
And
is the
one more
respondent?
matter is there, one more writ petition is there which is interlinked to this matter, your lordship. Maybe both may be connected and may be taken up on Monday.
Not Monday. Monday there are so
Kindly-
many. Wednesday will take.
Wednesday.
List along with so and so on Wednesday at the request of Lord Counsel the petitioner. No representation on behalf of the respondent.
Much obliged.
Yes, 46.
47.
Yes, 47.
Yes, I am for the respondent, my lords.
Yes.
Yes, my lord.
Yeah, petitioner.
On last
The
petition,
interim
my
order
lord.
also.
On last occasion, the order has been passed by this honorable court to furnish the details of the consulate for the purpose of cross-examination of the petitioner, my lord. He is staying in the US.
Informed the party. I have informed the party, he has made an making effort. I did not get the information. He is
My lord,
staying in USA.
I am
What is
having
this
the
order?
information.
Order is withdrawing the video recording of evidence by the video conference and direct me to personally present before the court.
Then that is correct.
That has been stated now with an information that I should give particulars as regard the where I could get the consolation nearby in Texas.
All those things are not possible. Consulate people have no other work but to take,
As for the they have
already.
evidence is already recorded.
Take a chance, you can take a chance because I have dismissed so many cases that unless until the rules are amended. In this way, the video conferencing does not, because demeanor of the witness, prime witness is very much essential. And that too in these matters where there are so many allegations that are made, it
is
cannot
only
be done.
MC proceedings.
I know, MC proceeding.
Have it after vacation.
Yes. This is
My lord,
matter after vacation.
My
Interim order may grant.
interim order may be vacated, my lord. I will oppose for interim because
Interim
this is
order.
the tactics he adopted not only in this case, another case also same thing done. Nor paying maintenance, nothing, my lord.
There two matters clubbed together. Criminal petition 125 proceeding and the MC petition.
Who filed the MC petition?
MC petition was filed by me.
You will file the MC petition, you will sit in yours and you should be examined from there.
No, there are already cross-exam, 90% of the cross-exam is already completed
To video conferencing.
through video conference. It only further examination, cross-examination was there. To that extent it was.
I have to dismiss the petition because how when the consulate people will come? How when the consulate will
even-
work there?
Even
No,
that
no,
is,
when the consulate will work, when are the timings
Rule
of?
5 does not contemplate. It is only in case of an allegation, he being an accused. If he is staying there, then the consulate
There
is
is a confusion in that, in those rules. That's why I said, unless and until those rules are amended, we cannot follow that. Until such time, one has to come physically.
interim order may be extended.
No, I
How
will
can it be
oppose, my lords. I am ready for arguing the matter.
Physical appearance is.
You tell the date when you will come. I'll record it and
Yes, ma'am.
I'll
I have to
dispose of the
consult.
recording. Get instructions. List this matter on Wednesday. By the time the petitioner shall get specific instruction when the petitioner is going to appear before the court for cross-examination.
Yes, ma'am.
Yes.
Till then,
Interim order only granted is extended till then. Call.
Number 45. Omkar Gulab.
Actually, petitioner in this matter, Lordships, the matter has been settled before the mediation center. So hence you're withdrawing the this thing, matter.
You take that.
There's a mediation agreement along with it on page 17, para number 7. We have mentioned that we will be withdrawing this writ petition, Lordships, in this. Page 17, para number 7, Lordships, in this.
A memo is filed stating that the GNWC number 224 of 2024 has been settled before the mediation center. Since nothing survives for consideration, in the light of the settlement between the parties, the writ petition is dismissed as infructuous.
Good for Lordships.
Final hearing, cell number 48, Abu Bakr Shafi. For petitioner.
Appear for petitioner. Kindly pass over.
I think yesterday I told you this. You will not ask for password.
10-15 minutes, please.
Call this matter at 1 o'clock.
Serial number 36.
If he is not present, I'll dismiss it on the ground. Next.
Cell number 49. Cell number 49.
My lords, I appear for the respondent in this matter, my lords. A week times may be granted in this matter, my lords.
No representation on behalf of the petitioner. Counsel for the respondent seeks time. This is matter after vacation.
Cell number 50. 50, Jai Prakash Reddy, parted matter.
Lords, I am for the respondent.
Yes.
Lords, now, my lords, there appears to be, my lords, an element of, my lords, settlement between the parties. My lords, we'll just, my lords, explore because a report has, my lords, now come regarding, my lords, the paternity test. Lords, now, my lords.
So for that, your client should be.
I understand, my lords, we have advised.
Cause for making those kind of allegations
Yes,
against
my lords, I
the
absolutely
women.
understand.
Now we should say, like, whatever it is, like, you should pay 1 crore for that.
Now, my lords, that is why we have advised the
We
party.
shouldn't, it's not, it has become a practice now.
Absolutely, my lords. Now, my lords, there is some, my lords, element. Now,
We will, now recording it, I'll pass orders.
now my only request is, my lords,
Why should, if had this proposal had come from him prior to all these tests, we would have, court would have appreciated it.
correct. Now, my lords,
But not at
because
this stage because you are at a receiving end now.
my only request is, my lords, if, my lords, my lords, the entire litigation can be, my lords,
How?
quietus, my lords,
How,
can be
how?
reached. Settlement, my lords, my.
What is the settlement that you're proposing? Not for the sake of adjournment.
No, absolutely not, my lords. I, in fact, my lords, spoke
What
to
is
my
that
senior.
proposal? There should have been a proposal by this time. What is that?
On
What
the
is
last
it?
date, my lords, he said, my lords, he would want to, my lords, talk terms with the other
Did he
party.
speak to? Did he
No,
speak to
not
the?
directly to them. We, my lords,
petitioner?
put a word, my lords,
Oh,
to.
he has not,
Not
like
to, my
he-
lords, my.
what is the proposal you have given? You have not given any proposal, I
Your
think.
lordship has referred this matter for mediation to Srimati Sushila.
What happened there?
Then the mediation has filed.
Huh?
Mediation has filed.
But they have not appeared.
That is before the report.
Before the report, my lords. That was before the report.
May I pass on the report?
ಆಗಿದ್ಯಾ? ಏನಾಗಿದೆ?
Report ಬಂದಿದೆ, positive ಬಂದಿದೆ.
ಅಲ್ಲ DNA report ಅಲ್ಲ.
He is referring to the DNA report. Yes.
So I've gone through the report. That is why, my lords, I spoke to my senior, lords. My senior, my lords, now has asked, my lords, the parties to, my lords, have a, lords, talk within the office, my lords. We will
Like,
schedule
give
it,
me
my lords.
some proposal. What is your proposal? Then we will
Lords,
see.
there were- I,
Like, if he is ready to take back her, then we are ready.
From your client, but first the proposal should come.
yes, my lords.
So then if the proposal comes on one or the other, if they're not agreeing, then the question of
Correct.
negotiation
I
will come.
understand, my lords. In fact, I was part of, my lords, the mediation discussion on the last, my lords, around. Now, my lords, because after the, my lords, report, on the last date, my lords, before the family court, my lords, he
Tell
made a
your client
request.
that, for making these kind of statements before the court and all on, then he'll face the consequences.
That's my only request is, my lords, now, my lords, I've made a request to my lords, have a scheduled meeting on, my lords, Monday at our office, if at all, my lords, because considering, my lords, the parties.
We'll do one thing. I'll take up this matter on Wednesday.
Please.
Yes,
Yes,
yes.
whatever it is, but on Monday, on Wednesday,
No,
I'll
my
pass
lords, I will
orders
not,
on,
my lords, I will not take
on
any,
the
my lords.
merits of it,
Yes,
no
yes, my
further
lords.
adjournment.
Yes, yes, my lords. In fact, my lords, I kept, my lords, the objections ready, because, my lords, now my senior made a proposal, my lords,
I know
to.
that objections you can't file now.
No,
that's why
I
you
have
stopped.
kept it ready, my lords, I've got it notarized, my
Then
lords. I
counsel for the petitioner placed before the court, the DNA report, has filed a memo along with the DNA report where the report shows that the respondent is the biological father of the child. It is submitted that there is a likelihood of settlement and they'll be meeting in the respondent's office on Monday. Let's this matter on Wednesday. By the time, if the compromise talks do not work out, court will pass orders on the
Yes,
merits
yes,
of it.
absolutely. Grateful.
51,
Top of the list, my lord, on Monday, Wednesday. Top of the list.
Yes.
Yes.
Wednesday on the top of the list. Yes, 51.
number 51, N. Kumar for petitioner, Ishan Tevi,
Kindly permit me to withdraw the petition, my lord.
This,
Yes, my lord.
the place
Section nine-
of,
Section 9 petition.
Section 9 of,
Section 9 petition, yes.
the memo is filed. The land counsel appearing for the petitioner submits that he may permit it to withdraw the writ petition, accordingly dismissed as with.
Sarma.
Yes.
Number 53.
Yes.
That matter moved at the end of the list.
Yes, where is that?
Matters moved at the end of the list. That MS Prashant. List number 2, MS Prashant. HS Prashant.
Yes, that's the only matter.
One more MFA. That is Divya Page.
For the appellant, my lord. My lord, the learned MSCT, my lord, judge of MSCT, my lord, despite he doesn't have territorial jurisdiction, my lord, has passed a judgment, my lord.
Oh, yeah. What is the
My
mention
lord,
you made in the morning?
My lord, that is page number 12, my lord. He noted that despite service of notice, respondent remained absent, press disparate. My lord, at that time, my lord, the appellant, my lord, suffering from cancer. He is having the medical bills, my lord. Tomorrow I will go and convince the judge, my lord, the notice has not served on me, my lord. But despite this, he is noted in the judgment. It is noted like
What is the effort made by you to see whether the notice is served on you or not?
My lord, yesterday, my lord, when they come up with the attachment order, my lord, then he rushed to the Bangalore and I have immediately filed the case, my lord. He is a cancer patient and senior citizen, my lord.
Who are you in this?
My lord, I am the employer, my lord. My lord, the deceased Lakshmi, my lord, was working.
Come to the cost item at page number 10.
Please, my lord. I am the manager, my lord.
Bapaya Anita.
Bapaya Anita is the, my
Panya
lord.
Estate.
My lord, the name of me also not shown, my lord. But in my petition, caste title, my lord, I have mentioned, my lord. Page number 3.
You're the manager of the estate.
Please,
How are you concerned with this? Manager means you're the owner of the.
owner, my lord. I am the owner.
What is the amount that is granted?
My lord, amount, my lord, 12 lakhs, my lord. 12 lakhs.
Whether he is employee or not?
She was an employee, my lord. Despite, my lord, she was earning 399 per day, my lord. That was not shown to the court. Court has, my lord.
You have the record to show?
Yes, my lord, I have the record. If
You're
permit,
paying
my lord.
399.
My lord.
You're paying 399 per day.
Please, my lord. I have the records. I have all the records, my lord.
According to you, how much should be the amount?
My lord, not more than.
No, there should be a calculation. You can't
My
say
lord,
not
my-
more than.
My lord, the court has taken 21,000 per month, my lord. As a
Oh, basing on what?
my lord, kindly take, my lord.
As per the notification, it is 14,000.
Please, my lord, kindly take, my lord.
Calculated 14,000, how it will be? Let's do the
Kindly take,
calculation.
page number 18, my lord.
Page number.
18, my lord.
So where is, how the calculation is done?
The action took place on 19/12/2025.
So, yes, we'll see here.
Yes, my lord.
The weight for the purpose of calendar, taken
But
15,000.
why not
only.
page number 16, my lord?
No, quoted taken 15,000. Where from you're thinking that it's 21,000? Come to paragraph number 11.
11, my lord.
Quoted taken 15,000.
Yes,
And 50% of it comes to 7,500 into the multiplied with a factor. It's coming to 12,47,000, but not 21,000 as you're saying.
my lord, one more aspect, my lord. The court has, my lord, kindly see the page number 19, my lord.
Yes.
Order portion, my lord. Last para. The petitioner number 2 is entitled for total compensation of rupees 12,47,175 together with interest rate of 12% per annum from 19/1/2024 till realization of entire amount, and also receive penalty amount of rupees so and so. He has also imposed penalty, my lord. The respondent is liable to pay 12,47,175 with interest 12% per
If you
annum.
want, I can say this as far as this penalty amount. That amount.
My lord,
somebody
my lord,
died.
my question is, my lord, the root cause of the claim itself is without jurisdiction, my lord.
Why?
My lord, I will take your lordship to EC Act, my lord, for a moment, my lord. Employees Compensation Act, my lord.
You can tell.
My lord, section 21, my lord. My lord, venue of proceeding and transfer. Where any matter under this act is to be done by or before a commissioner, the same shall subject to provision of this act and any rules made hereunder be done or before the commissioner for area which.
They're taking all the grounds under the sun. You will go here. When it is not working out, you will come here, then there. Ultimately, it's a case of accident, somebody's death.
My lord,
I will not grant a blanket order at any cost. What is the amount that you're going to pay is the question.
My lord, let me serve the summons on the councils.
I will not grant a blanket order. I'm very clear on that.
My lord, I am not asking. I am now, my lord. I am not pressing for stay, my lord. The only.
Why did you?
My
ask
lord,
for,
since
lunch
attachment
motion?
order is passed, my lord, I will convince the trial court, my lord, that court didn't have jurisdiction to pass such order, my lord.
First of all, you have to convince this court that
My lord.
such an order the court will pass.
My lord, kindly take page.
I am not, whatever it is, I will not pass any order. It's a blanket order. If you want an interim order, that has
My
to
lord,
be on some
as
condition.
of now, my lord, I will pay around 3,50,000, my lord. I will deposit the amount in the registry of this honorable court, my lord.
It has to be 50%. I can grant stay as far as that penal amount is concerned. This amount 50% has to be paid. If penal amount is also taken, it will come to, it will become 19 lakhs.
My lord, for 2 minutes pass on, my lord, I will.
Yes.
Matter passed over. Till number 48, Abu Bakr Shafiq.
Petition. 30. Huh? 230.
But
Let's see if the vacate stay is there. I will vacate it and post it.
Yes, please.
I'll vacate the interim order. This matter is listed, is coming up for final hearing before this court. And so many times, right from 14/8/2025, 28/8/2025, 14/11/2025, and 4/12/2025, this matter has come up before the court. Yesterday, when the matter has come up, the counsel for the petitioner has sought for time. Today also, the petitioner is seeking time. Hence, the stay that is granted on 13/1/2025 is vacated. This is matter on in the month of June 2026. Yes.
List number 2, Prashant HS, mood matter.
What is your matter?
Serial number 41.
Sorry, my lord. Serial number 41, my lord.
It's already adjourned.
Adjourned, my lord. Some urgency is there, my lord.
One document. One
What
doc.
urgency in RPFC of 2024?
He appeared in this matter, my lord, your lordship. Kindly, the urgency is that, my lord, the respondent has to pay her daughters and sons fees, my lord. It is in requirement, my lord. Yes, it's in due, my lord. The documents are available to show that. My lordship might kindly take up this matter by Monday or Tuesday, my lord. I shall argue the matter. We have great help, my lordship.
Huh? 41, this is matter on
One more document.
13th of November.
15.
Third, I mean, on not 15th, 9th, 12th, there is some.
Please, my lord.
Please.
Oblige.
I do play.
Done?
That HS Prashant.
Anyway, he's not there. Huh? What to do? Adjourn this matter next week, Monday or somewhere. Where is he?
In 2 minutes.
Yes.
My lord, he is ready to pay 50% of the amount in span of 1 month, my lord, because he is a cancer patient, my lord.
Yes.
For that reason, my lord.
The present MFA is filed by the employer questioning the order passed in ECA number 6 of 2024, whereby the court had granted an amount of rupees 12,47,175 as compensation and also to pay penalty of 6,23,587. When counsel appearing for the appellant submits that. What is happening? When counsel appearing for the appellant submits that it's an ex parte order, no notice is served, and in fact the cause title also do not disclose the name of the petition appellant. It is submitted that the court which has passed this order has no jurisdiction and without any basis a penalty of 6,23,587.50 is levied. It is also submitted that the petitioner, the appellant, is a cancer patient. Next, considering the submission of the land council, they shall be stay of all further proceedings on the condition that the petitioner shall deposit. What is that 50% of the amount?
12,47,000.
6,23,587 within 4 weeks from today. Today, in case if the appellant fails to, and on such deposit, the respondents are at liberty to withdraw the amount. If the petitioner fails to pay the amount, the order granted by this court stands vacated without further reference to the court. Notice to the respondent.
Deposit in the registry of this court.
Anyway, wherever you want to do it in the lower court here.
Otherwise, my lord, they will not accept, my lord. Even trial court will not accept. Before this court, my lord.
Every day in appeals, I am passing hundreds of orders. They will accept. If I specify high court, they will not accept in the trial court. If I say high court, so that I just am saying deposit, wherever it is, they will. Yes, done.
Well, the order may be uploaded by today.
ಏನು ಮೈಕ್ ಸರಿ ಇಲ್ವಾ ಏನು ಅವ್ರೇನೋ ಹೇಳಿದ್ರು ಮುಂದಿನ ಬಿಟ್ರು ಏನೋ ಬೇರೆ ತರ ಕಂಪ್ಲೀಟ್ ಆಗಿ ಇದೇನೋ 17 ಕೆನರಾ ಬ್ಯಾಂಕ್ ಇದ್ದಾರೆ ನಾವು 13
So serial number 14. ಸಿದ್ಧಾರ್ಥಮನ್ಗೆನೆ
46 ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಂತ ಕೊಟ್ಟಿದಾರಲ್ಲ ಎರಡು ವೆಡ್ನೆಸ್ಡೇಗೆ ನೋಡಿ ಡಿಸ್ಕಸ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್ 46 ಸೀರಿಯಲ್ ಏನು ಬಂದಿಲ್ಲ ಸುಮ್ಮನೆ ರಿಪೀಟೇಷನ್ ಎರಡು ಬರುತ್ತಲ್ಲ ವೆಡ್ನೆಸ್ಡೇಗೆ ವಿವಾದ ಮ್ಯಾರಿಡ್ ಇದೆಲ್ಲ ಹೇಳಿದ್ದೀನಿ ಏನಕ್ಕೆ ಯೂಸ್ ಇದೆ ಏನಕ್ಕೆ ಮಾಡ್ತೀರಾ ಮೇಡಮ್ ಟೆನ್ಷನ್ ಜಾಸ್ತಿ ಎಷ್ಟು ಸರಿ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು ನಾನು ಮೊನ್ನೆನೇ ರಂಜಿತ್ಗೂ ಹೇಳಿ ನೋಡಪ್ಪ ಇದನ್ನ ಸರಿಯಾಗಿ ಬರ್ತಾ ಇದೆ ರೆಕಾರ್ಡ್ ಆಗ್ತಾ ಇದೆ ಅಂತ ಏನು ಬೇಕು ಈ ಮಿತ್ರ ರೆಕಾರ್ಡ್ ಆದ್ರೆ ಏನು ಪ್ರಯೋಜನ ಒಬ್ರು ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ತಗೊಳಲ್ಲ ಯಾರು ಕೇಳಿದ್ರೆ ಅವ್ರನ್ನ ಕಳಿಸ್ತೀನಿ ಇವ್ರನ್ನ ಕಳಿಸ್ತೀನಿ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ ಸರ್ ಗಂಗಾಧರ ಕುಡೀರಿ ನೀರು ಚೆನ್ನಾಗಿ ಕುಡೀರಿ ಆಗಕ್ಕೆ ಸರ್ ನಿಮ್ ನೀರು ನೀವೇ ಕುಡಿಬೇಕು ನಾವು ಕೂಡ ಹೇಳಲ್ಲ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 51 ಏನಾಯ್ತು ಅಂತ ತಿಳ್ಕೊಬೋದಾ?
ಸೀರಿಯಲ್ ನಂಬರ್ 51
ಹೌದು ಸರ್.
ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ರಲ್ಲ ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ವಿಡ್ರಾನ್ ಸರ್.
ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ವಿಡ್ರಾನಾ?
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 50 ಸರ್.
ಥ್ಯಾಂಕ್ ಯು ಸರ್.
10-12 10-12
ಓ ಡೇಟ್ ಹೋಗ್ಬಿಡ್ತಾ? ಓಕೆ
ಹೇಳಿ 15
50 50 50
50 ಜಯಪ್ರಕಾಶ್ ರೆಡ್ಡಿ ಅಂತ ಇದ್ರಲ್ಲ ಅದ?
ಅಲ್ಲ ಸರ್ ವೆಂಕಟೇಶ್ ಭಗತ್ ಸರ್.
50 ಅಲ್ಲಿ ಇಲ್ವಲ್ಲ ನೀವು?
ಇದು 20 ಬಂದ್ಬಿಡ್ತಾ? ಸಾರಿ ಸರ್ 19 ಮಾಡೋದು 20 ಮಾಡೋದು. ಸಾರಿ ಸರ್.
ನಮ್ ಕೋರ್ಟ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮುಗೀತು. ಇನ್ಯಾದನ್ನ ಸಬ್ಮಿಷನ್ ಇದೆಯಾ? ನೋಡ್ತಾ ಹೇಳಿ ಮೇಡಮ್ ಇವಾಗ ನಿಮ್ದು ಏನಂತ?
ಇದು ಮೇಡಮ್ ಹೇಳಿದ್ರು ಕ್ಲಾರಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ, ಯಾಕಂದ್ರೆ ಆಗ್ಲೇ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ. ಡಿಸ್ಪೋಸಲ್ ಆದ್ಮೇಲೆ ತಿರುಗಿ ಯಾಕೆ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂತು? ದಿಸ್ ಮ್ಯಾಟರ್ ಅಂತ ಇನ್ನೊಂದ್ ದಿವಸ ಆಗಿದೆಯಲ್ಲ ಯಾಕೆ ಅಂತ ನಿಮ್ದ್ರಲ್ಲಿ ನೋಡಿದ್ಯಾ ನೋಡಿ ಸರ್ ಅಂತ. ಏನಂತ ಗೊತ್ತಾ ಇಲ್ಲ.
ಇವ್ರೆ ಇಲ್ಲಿ ಮೇಡಮ್ ಕಾಯ್ದು ಹೋದ್ರು, ನೀವು ವೆಯ್ಟ್ ಮಾಡ್ಬೇಕು ತಾನೆ. ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಮೂವ್ ಮಾಡ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂದ್ರೆ ವೆಯ್ಟ್ ಮಾಡ್ಬೇಕು ಇವ್ರೆ. ಹೇಳಿ ಏನು ಅಂತ.
ಅರ್ಜೆನ್ಸಿ ಇದೆ. ಬಿಫೋರ್ 1:30 ಅಂದ್ರಲ್ಲ, ಅದಕ್ಕೆ 1 ಗಂಟೆಗೆ ಬಂದೆ ನಾನು.
ಬಿಫೋರ್ 1:30 ಅಲ್ಲ, ಅದು ಮ್ಯಾಟರ್ ನಮ್ದು ಎಷ್ಟು ಕ್ಲೋಸ್ ಆಗುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. ಸರಿ ಬನ್ನಿ ಚೇಂಬರ್.
ಮ್ಯಾಕ್ಸಿಮಮ್ ಕೊಡೋಲ್ಲ ಅದು.
ಡಾಟ್ ರೆಡಿ ಇದೆಯಲ್ಲ ಇದು ಎಷ್ಟು ಹೊಸದಾಗಿ ಏನ್ ಮಾಡ್ಬೇಕು? 51 ಚೇಂಬರ್ ಅಲ್ಲಿ 51 ಚೇಂಬರ್
ಅಲ್ಲ ಸರ್,
ಟೋಟಲ್ ಅಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ಬೇಕಲ್ಲ ನಾವು. ನಿಶಾಂತ ಅಡ್ವೊಕೇಟ್
551.
ಎನ್ ಕುಮಾರ್
Whatever corrected the serial number.
ವಿಡ್ರಾ ಮಾಡಿದ್ರಲ್ಲ ಸರ್, ವಿಡ್ರಾ ಆಯ್ತು. ವಿಡ್ರಾ ಡಿಸ್ಮಿಸ್ ಆಸ್ ವಿಡ್ರಾ.
Nishant.
ನಿಶಾಂತ್ ಹೇಳಿ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ.
Dismissed as withdrawn.
Yeah.
Okay, sir. Thank you.
ಸರ್ ಇದು 36,844 ಅಲ್ಲಿ ಯಾರೋ ಅಡ್ವೊಕೇಟ್ ಇಲ್ಲದ್ರಲ್ಲ. Dash directed to take notice on behalf of the respondent bank. This is matter on 8812 ಅಂತ ಮಂಡೇ ಬರ್ಬೇಕಲ್ಲ ಇದು.
36 ಅಲ್ಲಿ ಆಗಿತ್ತು.
35 ಇದೇನಾ ಸವಿತಾ ಶೆಟ್ಟಿನಾ?
ಅದು ನೇಮ್ ಕೊಡ್ತೀನಿ ಕೋರ್ಟ್ ಆಫೀಸ್ ಕಡೆ ಅಂತ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನ.
ನಾವೇನಂತ ಮಂಡೆಗೆ ಹೆಂಗ್
ಫೋನ್
ಆಗ್ತದೆ
ಮಾಡಿ ಹೇಳ್ತೀವಿ.
ಹೇಳ್ತೀರಾ?
ಅವರು ಯಾರು ತಂದು ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನ. ಕೋರ್ಟ್ ಆಫೀಸ್ ಹತ್ರ ನೇಮ್ ಕೊಡಿ.
ಏನೇನೋ ಬರ್ತಾ ಇದೆ
ಬೆಳಗ್ಗೆಯಿಂದ
ನಂಗೆ
ಅದನ್ನ ಬ್ರಾಂಚ್ ಕಳಿಸ್ಬಿಡ್ತೀನಿ. ಅದನ್ನ ಚೇಂಬರ್ ಚೇಂಬರ್ ಮಾಡಿ ಇಲ್ಲಿ ಕಳಿಸ್ಕೊಡ್ತೀನಿ. ಅದು 5 ಗಂಟೆಗೆ ಇರೋದು ತರಬೇತಿ ಮೇಡಮ್ ಸಪ್ರೇಟ್ ಕೊಡೋದು.
ಸಪ್ರೇಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ ಹೇಳ್ಕೊಡ್ತೀನಿ. ಮೇಡಮ್ ಅಲ್ಲಿ ಸೆಂಟ್ರ್ ಬರ್ತಾನೆ ಅಂತೀರಿ ಸರ್ ಫುಲ್ ಬೆಂಚಲ್ಲಿ ಈ ಕಡೆ ಸುನಿಲ್ ಜೊತೆ ಅದು ಸಾಹೇಬ್ ಅಂತ ಸೆಂಟ್ರ್ ಮೇಡಮ್ ಆ ಕಡೆ ವಿಜಯ್ ಕುಮಾರ್ ಪಾಟೀಲ್
ಸೀನಿಯರ್ ಯಾರು ಸೆಂಟ್ರಲ್ ಕೂತ್ಕೊಳ್ಳೋದು.
ಹೌದಾ ನೋಡ್ಬೇಕು ಅಲ್ಲಿ ಕೇಳ್ತೀನಿ ಬಿಡಿ ಕೊಟ್ಟು.
ವಿಜಯ್ ಕುಮಾರ್ ಎ ಪಾಟೀಲ್ ಲೆಫ್ಟ್ ಸೈಡ್,
ಮೇಡಮ್ ರೈಟ್ ಸೈಡ್.
ಮೇಡಮ್ ರೈಟ್ ಸೈಡ್, ಸುನಿಲ್ ದತ್ ಯಾರು ಸೆಂಟರ್. ಸೀನಿಯರ್ ಅವರೆಲ್ಲ
ನೋಡ ಬಿಡಿ ಸರ್ ನಾನು ಕ್ಯಾಬಿಟ್ ಇಡ್ತೀನಿ
ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇಡಿ. ಅವ್ರು ಸೆಂಟ್ರಲ್ ಇರ್ತದೆ, ನಮ್ಗೆ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇಡಿ. ಯಾಕಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ಸೀನಿಯರ್ ಇವರು ರೈಟ್ ಸೈಡ್. ಇವರು ವಿಜಯ್ ಕುಮಾರ್ ಪಾಟೀಲ್ ಇಲ್ಲೇ ಇದ್ದಾರೆ, ಅವ್ರು ಲೆಫ್ಟ್ ಸೈಡ್ ಬರ್ತಾರೆ.
ಮಧ್ಯಾಹ್ನ ಇದೆ ಅಂತೀರಾ? ಮುಗಿದ ಮೇಲೆ ಎತ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ಚೇರಲ್ಲೆಲ್ಲ. ನಮ್ಮ ಎಲ್ಲ ಕೊಟ್ಟೆ ಸರ್, ಅದೇ ಅಲ್ಲೂರು ಅಲ್ಗುರಿ ಅಂತೀರಿ, ಇಲ್ಲಿ ಅಂತೀರಿ. ಅವ್ರು ಚೆಕ್ ಮಾಡ್ಕೊಂಡು ಹೋದ್ರೆ ಬರ್ದಿರು ಕಂಪ್ಯೂಟರ್ ಚೆಕ್ ಮಾಡ್ಕೊಂಡೆ ತಗೊಂಡು. ಇವರು ಏನಿಲ್ಲ ಹೇಳಿದ ಇದು ಅವ್ರದ್ದೇ ಅಂತ ಹೇಳಿ
ಎಲ್ಲ ಅವರು ಮೇಡಮ್ ಅವರು.
ಹಂಗೆ ಅದು ರೆಕಾರ್ಡ್ ಇಸ್ಕೊಂಡು 7 ಕೊಟ್ಬಿಡ್ತೀನಿ ಸರ್ ಫುಲ್ ಬೆಂಚ್ ಫುಲ್ ಬೆಂಚ್
46 ಏನಾಯ್ತು ಅಂತ
46 ಟೆಂಪಲ್ ಹೋಯ್ತಲ್ಲ along with connected number of the ಅಂತ.
ಹೌದು
31381.
ಹೌದು
ಅದ್ರ ಜೊತೆಗೆ ಬರುತ್ತೆ 8ನೇ ತಾರೀಕು.
ಓಕೆ ಥ್ಯಾಂಕ್ ಯು.
ಮೇಡಮ್ದು ಒಂದೇ ಒಂದು ಫೈಲ್ ಇಲ್ಲಿ ಇಟ್ಕೊಳ್ಳೋಣ. ಈಗ ಯಾವ್ದು ಎಂಡ್ ಆಫ್ ಲಿಸ್ಟ್ ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ ಅದು ಯಾರು ವಕೀಲ
ಮೇಡಮ್ ಏನೋ ನಿಮ್ ಚೇಂಬರ್ ಮಾಡೋದು ಎತ್ಕೊಂಡೋಗಿತ್ತು ಹೋಟೆಲ್ ಕರ್ಕೊಂಡ್ರು ಚೇಂಬರ್ ಬನ್ನಿ ಅಂತ ಕರ್ಕೊಂಡೋಗಿ
ರೋಲಿ ಬಿಡಿ
ಚೇಂಬರ್ ಬನ್ನಿ ಅಂತ ಅವರೇ ಮೇಡಮ್
ಎತ್ಕೊಂಡೋಗಿ ಅದೊಂದು ಸಪ್ರೇಟ್ ಕೊಡಿ.
ಒಂದು ಸಪ್ರೇಟ್ ಅದೇ 5
ಚೇಂಬರ್ ಇದೆ.
ಆಮೇಲೆ ಅದು ಫುಲ್ ಬೆಂಚ್ తీసుకొని ಹೋಟೆಲ್ ಕೊಟ್ಬಿಡ್ತೀನಿ ಏನ್ ಕ್ಯಾಮೆರಾ ಅವ್ರು ಜೋಡಿಸ್ಕೋತಾರೆ ಡಿಸ್ಪೋಸಲ್
ಇದೆ ಚೇಂಬರ್ ಸಪ್ರೇಟ್
ಹಂಗೆ ಮೇಲೆ ತಗೊಂಡೋಗಲ್ಲ ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಪೆನ್ಸಿಲ್ ಅದು ಕೇರ ಮೇಲೆ ತಗೊಂಡು ಗಾಡಿ
ಅವ್ರು ಸಾಹೇಬ್ರು ಇಲ್ಲಿ ಎದ್ದಿರಲ್ವಾ ಅಲ್ಲಿ?
ಇಲ್ಲ ಕೈಲಿ ಇಟ್ಕೊತೀನಿ ಇದೊಂದು ತಾನೆ ಇಲ್ಲಿ ಈ ಕಡೆ ಫೋಟೋ ಈ ಕಡೆ ಕೈಲಿ ಇಟ್ಕೊತೀನಿ ಆಮೇಲೆ ಇಡ್ತೀನಿ ಇದನ್ನ ಪೆನ್ ಆಮೇಲೆ ತಗೊಂಡು ಪೆನ್ಸ್ಕೊಂಡು ಇದೊಂದು ಗಾಡಿ ಹಾಕೊಂಡಿರ್ತೀನಿ ಆಮೇಲೆ ಅದು ಇದೊಂದು ತಗೊಂಡು ಅದು ಪೆನ್ಸಿಲ್ ಇದೊಂದು ತಗೊಂಡು ಎರಡು ಪೆನ್ನು ಎರಡು ಪೆನ್ಸಿಲು
ಒಂದು ಪೆನ್ ಹಿಡಿ
ಸಾಕಲ್ಲ ಸುಮ್ಮನೆ ಹಿಂಗೆ ಇಟ್ಕೊಂಡು ಹೋಗ್ಬೇಡ ಎರಡು ಪೆನ್ನು ಪೆನ್ಸಿಲ್ ಇಟ್ಕೊತೀನಿ
ಪೆನ್ಸಿಲ್ ಇಟ್ಕೊಡಿ.
ಎರಡು ಪೆನ್ ಇರ್ತೀನಿ ಪೆನ್ನೇ ಬರಲ್ಲ ಅವ್ನು ಬನ್ನಿ ಆಮೇಲೆ ನೀರು ಇಲ್ಲೇ ಇರ್ತೀನಿ ವಾಟರ್ ಪ್ಯಾಡು ಇದು ಎತ್ಕೊಂಡಿರ್ತೀನಿ ಗ್ಲಾಸಲ್ಲಿ ತುಂಬೆ ಇದು ಕೇರ್ ಇದು ತಗೊಂಡ್ಬೇಕಲ್ಲ ಸರ್
ಅದನ್ನ ಕನ್ನಡಕನ
ಹಾ ಬೇಕೇ ಬೇಕು ಇದು ಇಡ್ತೀನಿ ಸರ್ ಹಂಗೆ ಜೊತೆಗೇನೆ
ಅದ
ಜೊತೆಗೆ ಇಡ್ತೀನಿ ಇರ್ಲಿ ಇಡ್ತೀನಿ ಇದು ಚಿಟ್ಪಡಿ ಜೊತೆಗೆ ಇದೊಂದು ಮೇಡಮ್ದು ಇದೊಂದಲ್ಲ ಮೇಡಮ್ ಕನ್ನಡಕ ಮೇಡಮ್ದು ಇದು ಒಂದು ನೀರ್ ಗ್ಲಾಸ್ ಇಲ್ಲೇ ಎತ್ಕೊಳ್ತೀನಿ
ಕಳ್ಸಿದೀನಿ ನೋಡಿ ಇಂಚೆಂಬರ್ ಫೈಲ್ ಕಳ್ಸಿದ್ದೆ ಸರ್ ನಿಮ್ ಕೈ ಕೊಟ್ನಲ್ಲ
ಐತೆ ತಗೊಂಡಿದ್ದೀನಿ
ತರ್ತಾರೆ ಅದನ್ನೇಪ್ಪ ತರ್ತಾರೆ ಅವ್ರು ಹೊಸಬ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ ತರ್ತಾರೆ.
ಅದು ಇನ್ನೊಂದು ಡೇಟ್ ಆಯ್ತಾ ಏನಾಯ್ತು ಅದು ಇನ್ನೊಂದು ಫೈಲು
ಅದು 2 ಗಂಟೆಗೆ ಅವ್ರಿಗೆ ಸರ್ ಒಂದು ಇನ್ನೊಂದು ಫೈಲ್ ಇಲ್ಲೇ ಇಟ್ಟಿದ್ದೀರಲ್ಲ ಸರ್ ಸ್ಟೇ ಆಯ್ತು
ನಂಗೆ ಹಾಕ್ಬಿಡ್ತೀನಿ ಕೊಡಿ
ಅಲ್ಲಿದೆ